Let's see if it's running here. So this is Judge Young, for those of you who don't know him. He's going to be taking over. We got.
And Judge, just real quick, off docket matter, we're about anywhere between today and 6 days from likely giving birth. So,
Congratulations.
if I run out, I'm probably not coming back. So I'm sorry about that.
Not a problem.
Forward a bit.
Is this a boy or a girl?
It's a boy.
This your first one?
Second.
Second, okay. Congratulations. Okay. We have Genghis Capote.
Morning, Judge. Richard Mendoza on behalf of Mr. Capote.
Morning, sir. If you'll please tell us your name. Okay, Mr. Capote, you are here for arraignment this morning in case 20 CF 3278. You've been charged in this case with fleeing or attempting to elude a law enforcement officer with siren and lights activated. That charge is a third-degree felony, which is punishable by up to 5 years state prison, up to 5 years probation, and or a fine of up to $5,000. Do you understand what you've been accused of, sir?
I enter plea of not guilty at this time, Your Honor.
All right, Mr. Capote will accept your plea of not guilty. Your case is set for jury trial during the trial period, which will begin on March 8th. Pre-trial will be on February the 24th. And your attorney will be talking to you between now and then. You may be able to resolve the case prior to that. Thank you, sir. Karen Castillo Abraham.
Sorry.
Ben King on behalf of Ms. Castillo.
Yeah.
All right, good morning, ma'am. State your name, please. Ms. Castillo Abraham, you are here for arraignment in case 20 CF 3080. You've been charged in this case with battery on a law enforcement officer in count 1, in violation of pretrial release condition on a domestic violence case in count 2. Count 1 is a third-degree felony, which is punishable by up to 5 years state prison, 5 years probation, and or a fine of up to $5,000. And count 2 is a misdemeanor, punishable by up to 1 year in the county jail, 1 year probation, and or a fine of up to $1,000. Do you understand what it is you've been accused of?
Yes, sir. Your Honor, we'd like to enter a plea of not guilty at this time.
All right, we'll accept the plea of not guilty. So we'll go ahead and set this for the February 1st trial period. Pre-trial will be January 20th. Thank you, Ms. Castillo Abraham.
Is there a possible way for us to use my attorney?
You can do that. It's not right now because we wouldn't be able to do that privately, but Mr. King, if you'll get a hold of us.
Ms. Castillo, I will see you soon.
Mr. Lindsay, you can go ahead and address your case if you wish. Yes, sir. You have Jack Lindsay.
President of the audit board. From the last.
Okay. Well, then, yeah, I'm afraid we can talk about it, but if you want him to be part of the conversation, we'll have to do it once we get through with the jail folks, if that's all right. All right, thank you. All right, Dallas Francis.
Ben King on behalf of Mr. Francis.
All right, good morning, Mr. Francis. State your name, sir. Okay, Mr. Francis, the state has filed an amended information in case 20 CF 849. You remain charged with grand theft of a motor vehicle, which is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and or a fine of up to $5,000. I'm not sure what the amendment was.
Your Honor, the amendment was to clarify the victims.
Okay, it added a second potential or victim, is that correct?
That's correct, Your Honor.
Okay, so the change in the information just changed the name of the alleged victim from Lindsay Testa to Lindsay Testa or Sharon L. Martinez Reyes. So, Mr. King, how's your client wish to plead?
Not guilty, Your Honor.
Okay. Accept the plea of not guilty to the amended information. The case remains set for trial on is set for the February 1st trial period. Pre-trial is January 20th, sir. All right, thank you. Jordan Franco.
Thank you on behalf of Mr. Franco for the Public Defender's Office.
State your name, sir. Ms. Franco, you were charged in case 20 CF 3143 with trafficking in 4 grams or more of heroin. That charge is a first-degree felony punishable by up to 30 years state prison. It does carry a mandatory 3-year prison sentence if you were convicted as charged, as well as the possibility of probation for any period of time between the 3-year mandatory minimum and the maximum of 30 years that is not imposed as a state prison sentence, and a mandatory fine of $50,000. Do you understand what the charge is, sir?
Yes, Your Honor.
Mr. King?
Not guilty, Your Honor. I apologize.
Right. We'll accept the plea of not guilty. This was October arrest. You'd be ready by the February 1st trial period, do you think, Mr. King?
That should be sufficient time, Your Honor.
Okay. Set for the February 1st trial period. Pre-trial will be January the 20th. Thank you. Gabriela Gonzalez Hernandez.
She's out of custody.
Oh, she's not in custody. Okay, I apologize.
Your Honor, I have had contact with Ms. Hernandez before, and I would like to waive her appearance and plea not guilty unless she's next door.
That's fine. If that's what you wish to do that, we'll accept the plea of not guilty. You think she is next door or is not?
I haven't checked in
Okay.
about half an hour.
Okay. Well, this looks like it should be a simple enough case. We'll set it for the February 1st trial period, pre-trial, January 20th. Okay. And Gentry Grayson, I believe, is out of custody, so we'll pass that. Lonnie Hammond. Clerk is listed as her in custody. State your name, sir.
Lonnie Hammond.
Okay, Mr. Hammond, you're here this morning in 3 cases. In case 20 CF 2936, you are charged with possession of heroin in count 1 and possession of drug paraphernalia in count 2. Count 1 is a third-degree felony, punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Count 2 is a misdemeanor, punishable by up to 1 year in the county jail, 1 year probation, and/or a fine of up to $1,000. In case 20 CF 3177, you're charged with grand theft of a motor vehicle in count 1, possession of methamphetamine in count 2, and possession of drug paraphernalia in count 3. Counts 1 and 2 are both third-degree felonies, each punishable by up to 5 years state prison, 5 years probation, and/or fines up to $5,000. Count 3 is a misdemeanor, punishable by up to 1 year in the county jail, 1 year probation, and/or a fine of up to $1,000. And in case, okay, I'm sorry. Can you hear me better now?
Yes, sir.
Okay, in case 20 CF 3178, you're charged with driving while license revoked as an habitual offender. That charge is a third-degree felony, punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Do you understand what the charges are?
Yes, sir.
Before you do that, it might be in your best interest to talk to your attorney first, who can tell you what it'd be in your best interest to say or not say. But first of all, Mr. King.
Yeah, Mr. I'm going to enter a plea of not guilty at this time. Mr. Hammond, my name's Ben King. I'm the attorney assigned to your case. I'll be out to speak to you very soon, okay?
I was just wondering if I could have my bond reinstated. Once I don't have bond.
Okay,
That's a possibility. Your attorney can talk to you and schedule a hearing if that's appropriate. So, Mr. Hammond, at this time, I'll accept the pleas of not guilty in these cases. Your cases, we'll go ahead and set them for the February 1st trial docket, pretrial January 20th. And your attorney will be talking to you and can address the bond matter as well as your options as far as resolving the cases. Thank you.
Thank you.
Charles Harvey?
He should be out of custody.
Oh, I'm sorry. You're right. You need to read the docket. Damon Ivy.
Richard Mendoza on behalf of Mr. Ivy.
Morning, sir. State your name, please. Mr. Ivy, you were here for arraignment in 2 cases this morning. In case 20 CF 3028, you were charged with delivery of a controlled substance within 1,000 feet of a place for worship. In count 1, unlawful use of a two-way communication device in count 2, and possession of drug paraphernalia in count 3. Count 1 is a first-degree felony, punishable by up to 30 years state prison, up to 30 years probation, and/or a fine of up to $10,000. Count 2 is a third-degree felony, punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. And count 3 is a misdemeanor, punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. In case 20 CF 3046, you were charged with possession of a controlled substance in count 1 and possession of drug paraphernalia in count 2. Count 1 is a third-degree felony, punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. And count 2 is a misdemeanor, punishable by up to 1 year in the county jail, 1 year probation, and/or a fine of up to $1,000. Do you understand what the charges are against you, sir?
Yes, I do.
Thank you.
For a plea of not guilty at this time, Your Honor.
All right, we'll accept the pleas of not guilty in both cases. I will set both cases for the February 1st trial docket, pretrial January 20th. I'm sorry?
I have a question because I was out on Baltimore for this case. I was out on PCR, and you gave me PCR for the case for the first one, and then it came 2 weeks later after I got out, we got the second case on. So how does that meet, violating my PCR? I never violated PCR. They waited till I got out You understand? I was out trying to get my history straight with these calls. And, they revoked my PCR because of that.
Okay.
If I may, very.
Well, the first appearance judge did revoke the bond based on the new arrests in case 20 CF 3046 and 20 CF 3028. What's it, 3046? Is that a pending case too?
No, Judge, that's the one that we just arraigned him on. The second.
3046?
3046, yes, sir.
Okay.
Yes.
All right, so the bond was revoked based on the arrest in 20 CF 3423. And what's happening with that one?
It's not filed, it's in Division 201.
And it looks like it was a warrant arrest, not a new law violation.
So it
And so
occurred
therefore.
prior to his release?
Exactly, Your Honor.
Okay,
And I just hadn't had an opportunity to do a written motion yet. I had just spoke to Mr. Ivy about that.
all right. Mr. Ivy, you may be entitled to your bond and pretrial release being reinstated on the cases that you were out on before they charged the 20 CF 3423. Your attorney will handle that for you.
And Judge, I'll file a motion on behalf of Mr. Ivy by the close of business today, so that
Okay,
we can try to readdress it sometime this week.
we can absolutely address it this week. I don't know if the state's familiar with the situation at this point.
I believe so, Judge. I believe it was a warrant arrest on a synthetic cannabis case. That's 3423. I think that's what ended up causing the incarceration at the moment with the bond revocation.
Right, but it's for something that occurred prior to his,
I'm not entirely sure on the date, but I'll
Okay.
do is I will look into it today since that's a case in another division from another ASA. I will subsume that case and I'll speak with Mr. Mendoza today. We'll get it worked out.
okay. Mr. Ivy, your attorney's working on that. I think we'll address it in short order, sir. Thank you.
Thank you, Judge.
That'll be the February 1st dates too, I think. On that. Okay, Amanda Marrero.
Ben King on behalf of Ms. Marrero.
She also has two other cases that were set for plea status today.
What? I'm sorry.
Plea status today.
Yes, Your
Okay.
Honor, that's correct. She has this new law charge that she's being arraigned on now. There was a plea offer prior to the new law, and I don't know if that offer still stands. I don't have my laptop in front of me to see if I've gotten an email from the state that includes a global offer, but that was the plan. If the state does have a global offer for the case, I can convey it to her. This
All right. Well, first things first, Ms. Marrero, you were here at this time in case 20 CF 3467 for arraignment. You've been charged with petty theft with two or more prior theft convictions in count 1 and resisting merchandise recovery in count 2. Count 1 is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Count 2 is a misdemeanor punishable by up to 1 year in the county jail, 1 year probation, and/or a fine of up to $1,000. Do you understand what the charges are?
Your Honor, we'll enter a plea of not guilty at this time.
Okay. And Mr. Hagner, are these your cases?
This current one is, Your Honor. The other two separate plea status are not.
Okay, then Mr. Breos. Okay. Is it going to be possible to come up with a global offer on all three cases this morning?
It would be better to reset it for another day, Judge.
Okay. And the cases look pretty straightforward. We could,
Would you like to set this for a plea conference, Your Honor?
we can do that. I don't know, do we have the jail feed on Wednesday? Yeah.
No, but we do have it tomorrow afternoon. Might be.
Yeah, we could, okay, we'll set it for tomorrow afternoon with,
Get a plea form if we get everything worked out.
yeah. Ms. Marrero, your attorney's going to talk to the state to see what possibility is for resolving all three of your cases. And he'll talk to you, and if that's something you want to do, we'll call the case back tomorrow afternoon at 2 o'clock. And if you want to resolve all your cases, we can do it at that time. If not, we'll set them for trial dates. So we'll go ahead and recall case 20 CF 3467, 19 CF 3838, and 19 CF 4329 tomorrow at 2 o'clock. All right? Thank you, ma'am.
Thank you, Your Honor, and thank you, State.
Okay. We have Leandro Obenauer, and I believe he may be in custody in Orange County. Do you know on that, Mr. Mendoza?
I'm sorry, Your Honor, let me double check.
I don't believe he was transported, Your Honor.
Right, that's...
I could waive his appearance and enter a denial of the violation at this time. Make contact with him.
Okay, this is an 04 case.
Yes, Your Honor, he's still in Orange.
All right, then, you feel comfortable doing that?
Yes, Your Honor.
Okay. So we'll accept the oral waiver of arraignment by counsel and the denial of the violation. We'll set the case for a violation probation hearing on January 28th with a status hearing on January 26th.
Thank you.
All right, Jillian Starks.
Richard Mendoza on behalf of Ms. Starks, Your Honor.
Morning, Ms. Starks. State your name, please. Ms. Starks, you've been charged in case 20 CF 3275 with aggravated battery. That charge is a second-degree felony, which is punishable by up to 15 years state prison, up to 15 years probation, and or a fine of up to $10,000. Do you understand what the charge is?
Judge will enter a plea of not guilty, but for the court's information, she has VOP status set for tomorrow. And I don't know if we could get this to track with that.
I have it for January 26th.
Oh, is it? Okay, I thought it was tomorrow.
Two cases.
I'm going to set this case for jury trial during the trial period beginning March 8th with a pretrial on February 24th. And we'll call it up for a status on January 26th with her VOP case.
Thank you, Judge. And if we can resolve this all matters, I'll call Ms. Keene and get it enough court.
All right, so Ms. Starks, your case is up for trial. Mr. Mendoza will be in touch with you. Talk about your options on resolving all your cases. Thank you.
Thank you, Judge.
Jeremy Fisher. Morning, sir. Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? State your name, sir. All right, Mr. Fisher, you are here this morning in case 19 CF 3721. And your lawyer, who's the defense on this? Jeremy Fisher?
Your Honor, Jose Lopez.
Okay, Mr. Lopez is appearing via Teams. I can see him, but you can't. Let me know if you're unable to hear Mr. Fisher. If you do need to talk to him at any time, we'll take a break and you may do so. Mr. Lopez has submitted a written plea form in this case, which indicates you wish to resolve the charges by entering a plea of guilty to burglary of a dwelling as charged in count 1. Petty theft of $100 or more is charged in count 2. Criminal mischief as charged in count 3. Burglary of a dwelling is charged in count 4. Burglary of a conveyance is charged in count 5. And petty theft as charged in count 6. Is that what you want to do, sir? Okay. Counts 1 and 4 are both second-degree felonies. Each is punishable by up to 15 years state prison, 15 years probation, and/or a fine of up to $10,000. Count 5 is a third-degree felony, punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Count 2 is a misdemeanor, punishable by up to 1 year in the county jail, up to 1 year probation, and/or a fine of up to $1,000. And counts 3 and 6 are misdemeanors, each of which is punishable by up to 60 days in the county jail, 6 months probation, and/or a fine of up to $500. Do you understand, sir? Did you read and fully understand this written plea form? Do you have any questions at all about anything that's contained on the written plea form? Are you currently under the influence of any medication or other drugs or alcohol? Are you thinking clearly at this time? Has any person coerced, pressured, or in any way forced you to enter this plea? The recommendation is that you be adjudicated guilty of all counts. You'd be sentenced as to the felony counts to 4 years in the Florida Department of Corrections with credit for 366 days time served. The misdemeanor counts, you'd be sentenced to 365 days county jail on the first-degree misdemeanor and 60 days each on the second-degree misdemeanors. You'd be required to pay fine, court costs, fine, court costs, as well as restitution if applicable. Is that your understanding of the agreement? All right. You've been represented in this case by Mr. Lopez. Are you fully satisfied with his representation of you? You believe it is in your best interest to enter this plea of guilty? You understand that if you are not a United States citizen, entering this plea will subject you to deportation. If you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete the prison sentence that the court imposes, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand? You have the right to continue with your plea of not guilty and to have a jury trial to determine whether the state can prove that you committed these crimes. If you chose to go to trial, at your trial you would be presumed to be innocent. You could not be found guilty of any crime unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt. Do you understand? If you chose to go to trial, at trial you you would have the right throughout all proceedings to be represented by Mr. Lopez. You would have the right to confront and cross-examine any witnesses who testified against you. You would have the right to present witnesses and evidence in your defense at your trial. You are entitled to use of the court's subpoena power to require any witnesses you had to be present so you could present their testimony to the jury. You also would have the right at trial to testify yourself, or you could choose not to testify. And if you elected not to testify at your trial, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. Do you understand that you have those rights? By entering a plea of guilty, you're giving up each one of the rights that I've just talked to you about, as well as the other rights that are written on the plea form, and there will not be a trial in your case. You also, by entering the plea, are waiving your right to appeal any matters relating to your case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand? All right. Mr. Fisher, I find that you are alert and intelligent, that you understand the nature of the charges against you, you understand the penalties that you're facing, and you understand the rights that you're giving up by entering this plea. I find that your decision to enter the plea has been freely and voluntarily made, and that you've had the advice of a competent lawyer with whom you've expressed satisfaction. I've read the affidavit for arrest warrant by Detective Barra in the court file. Based on that affidavit, I do find there's a factual basis upon which your plea can be accepted. I'll accept your plea of guilty. Mr. Lopez, do you agree with the score sheet submitted that has 98.8 total sentence points?
Oh, yes, sir.
And state you're recommending downward departure sentence?
Judge, this is a downward departure based on Uncoer's plea bargain, understanding that the bottom of the guidelines was 52 points.
Okay, and is restitution an issue?
It is, Judge. There's two separate sets of victims, the Sanchez family and the Harris family. I've listed both of them. They've got good addresses. We're asking restitution be reserved. There's a calculation of the total loss, but you can take care of that.
All right, Mr. Lopez, is there any reason why we should not proceed to sentencing this morning?
No, Your Honor.
Is there anything further from the defense with respect to sentence?
No, Your Honor.
All right. All right, Mr. Fisher, at this time, the court having accepted your plea of guilty, you will be adjudged guilty of burglary of a dwelling as charged in count 1. Petty theft of $100 or more is charged in count 2. Criminal mischief is charged in count 3. Burglary of a dwelling is charged in count 4. Burglary of a conveyance is charged in count 5. And petty theft is charged in count 6. As to counts 1, 4, and 5, you'll be sentenced to 4 years in the Florida Department of Corrections with credit for 366 days that you've already served. As to count 2, you'll be sentenced to 365 days in the county jail with credit for 365 days time served. As to counts 3 and 6, you'll be sentenced to 60 days in the county jail with credit for 60 days time served. These sentences will run concurrent with each other. This is a downward departure sentence imposed pursuant to the uncoerced plea agreement between yourself and the state. You are ordered to pay court costs of $415, a $100 cost prosecution. There will be a fine of $500. I will order restitution to Glenn Harris and restitution to Ramon Luis Sanchez, and reserve jurisdiction to determine the amount of restitution. Were you retained, Mr. Lopez?
I was privately retained.
Yes, okay. You'll be ordered to pay the money that's owed in this case through the clerk's collection program at the rate of no less than $50 every month. You'll have until March 1st of 2024 to make your first payment. You'll be required to submit a biological specimen for inclusion in the Florida Department of Law Enforcement DNA database. Is there anything further with respect to the sentence in this case?
None from the state, Judge.
No, Your Honor.
All right, Mr. Fisher, you have 30 days within which you can appeal. The judgment and sentence was just entered in your case. If you wish to appeal and you are unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file a notice of appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir? Thank you, sir. Good luck to you. Charles Gonzalez.
Judge, when I called earlier, I don't know if he was already in there. He might be in the next group. Oh, actually, he's there.
Is this going to be a plea?
Yes, Judge. I tried to call early before you took the bench so that I could relay a last-minute thing. So,
You want to call it back at 2 o'clock?
if that's all right, that would be perfect.
No objection to the state. Andrew Braycock, Lauren Demers.
Morning, sir. State your name, please. Okay, Mr. Gonzalez, apparently there's some last-minute tweaking, I guess, on the conditions of your plea if you were to enter one. So we're going to call your case at 2 o'clock this afternoon. Your lawyer will talk to you between now and then. Then you can decide whether you want to go forward with the plea or not. All right, thank you.
Thank you, Judge. Thank you, Mr. Gonzalez.
Okay, Nishcam Liddick.
Kristen Kronk on behalf of Mr. Liddick. Your Honor, we will be leaving this set for trial.
Morning, sir. State your name. Okay, Mr. Liddick, you're here for a status hearing in case 20 CF 2806. You're going to set your case for trial on December 14th. Thank you, sir. Okay. We have Alan Maines. Alan Maines. Morning, Ms. Maines. You'll raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? State your name, please. I'm sorry? What was your name? You could, if you could state your name again, please.
Alan Young, Peter Manis.
Okay. It's Manis?
Either or, sir. Everything.
Well, how do you pronounce it? Manis?
Manis.
Okay. Okay, just a moment. Let me get your other case pulled up here. Fair enough. All right, Mr. Manis, you're here this morning in two cases. And Ms. Kronk, these are your cases, I believe.
Yes, Your Honor.
Okay, Ms. Kronk has provided the court with written plea forms that appear to have your initials and signature on them. Did you initial and sign these plea forms, sir?
Yes, I read them. I'm just everything about it. I initial signed myself.
Okay. Mr. Manis, in case 20 CF 2052, the plea form indicates you wish to enter a plea of no contest to possession of a controlled substance as charged in count 1 of the information. Is that what you want to do?
That is correct, Your Honor, yes.
That charge is a third-degree felony, punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. And it does carry a mandatory 6-month driver's license suspension upon the entry of an adjudication of guilt. Do you understand?
Yes, sir.
Okay. And state you'd be all processing count 2 in exchange for plea to count 1?
Yes, Judge, in each case.
Okay.
I have the score sheet, may I approach?
Yes. Okay, so in case 20 CF 2115, the plea form indicates you wish to enter a plea of no contest to possession of a controlled substance as charged in count 1. Is that what you wish to do?
Yes, sir.
And Ms. Kronk, the states indicated they're going to null process count 2, so with your permission, I'll mark that out on the plea form.
Yes, Your Honor. Thank you.
Okay. Again, the charge of possession of a controlled substance is punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. And it carries a mandatory 6-month driver's license suspension. Do you understand?
Yes, I do.
Did you read and fully understand the written plea forms?
I do, sir, Your Honor.
Do you have any questions about anything on the written plea forms?
No, I don't, Your Honor.
Are you currently under the influence of medication, other drugs, or alcohol?
No, I'm not, Your Honor.
Are you thinking clearly at this time?
Yes, I am, Your Honor.
Has any person coerced or forced you to enter these pleas?
No, Your Honor.
Your recommendation in these cases is that you would be adjudicated guilty of the charge you're pleading to in each case. You'd be sentenced to 120 days in the county jail with credit for 100 days time served as to each case, running concurrent. There would be a fine, court costs, public defender lien, and application fee, as well as a 6-month driver's license suspension. Is that your understanding of the agreement?
I understand it, Your Honor. I was told last Thursday that it was 100 days.
You were told last Thursday what?
That it was 100 days time served last Thursday.
Okay, the clerk tells me it's 100 days as of today.
She emailed me last week, and I told him I told Ms. Cronk as of today it would be 100 days.
Okay. The clerk is telling me that your attorney contacted her last week, and she gave her the credit for time served that would be current as of today because the plea was scheduled for today. So does that misunderstanding in any way change your decision to enter these pleas?
No, I just want clarification.
Fair enough. All right. Mr. Manis, you've been represented by Ms. Cronk in these cases. Are you fully satisfied with her representation of you?
Yes.
Okay. Do you believe it is in your best interest to enter these pleas?
Yes, I do.
You understand that if you are not a United States citizen, entering these pleas will subject you to deportation.
Yes, I do.
If you at any time are sentenced to state prison in Florida, and if you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any prison sentence imposed by the court, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Yes, I do.
All right, Ms. Manis, you have the right in each of these two cases to have a jury trial to determine whether the state can prove that you committed these crimes. You're entitled to a separate trial in each case, and the jury in each trial would only be aware of the case that you are on trial for before that jury. You would be presumed to be innocent at trial. You could not be found guilty of any crime unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt. Do you understand?
Yes, I do.
You would have the right to be represented throughout your trials by Ms. Cronk. You would have the right to confront and cross-examine witnesses who testified against you. You would have the right to present witnesses and evidence in your defense. You have the right to have the court order any witnesses you have to be present at your trial so you can present their testimony to the juries. You also have the right at each trial to testify yourself, or you could choose not to testify. If you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you elected not to testify as evidence of guilt. Do you understand? By entering pleas of no contest, you're giving up each one of the rights that I've just discussed with you, as well as all the other rights that are written on the plea forms. And there will not be a trial in either of your cases. You also, by entering these pleas, are waiving your right to appeal any matters relating to these cases, with the exception of the jurisdiction of this court to hear your cases and the legality of the sentences imposed. Do you understand?
That means there's no chance to appeal the trial.
Those, you'd be waiving your right to appeal any matters relating to the cases.
Okay, understood.
Does that change your decision to enter the plea?
No.
Okay. Well, the law changed from 1 year to 6 months. I don't know that's changed. It was 2 years, then 1 year, now 6 months. I don't know if it's changed from that. Okay. All right. Ms. Manis, I've read the arrest affidavits in each case by Officer Falali Fikri, and based on those affidavits, I do find in each case there is a factual basis upon which your pleas can be accepted. I find that you are alert and intelligent, that you understand the nature of the charges against you, the penalties you're facing, as well as the rights you're giving up by entering the pleas, and find your decision to enter the pleas has been freely and voluntarily made. You've had the advice of competent counsel with whom you've expressed satisfaction. I will accept the pleas of no contest. Ms. Cronk, do you agree with the score sheet with 21.2 total sentence points?
Yes, Your Honor.
Based on the score sheet, it appears that your client is entitled to a pre-sentence investigation.
We'll be waiving that, Your Honor.
Okay. That being the case, is there anything further to be said before sentence is imposed?
Nothing from the defense.
Nothing from the state.
All right, Mr. Manis, in case 20 CF 2052, you'll be adjudged guilty of possession of a controlled substance. Sentenced to 120 days in the county jail with credit for 100 days that you've already served. You'll be required to pay court costs of $415, a $100 cost of prosecution, a fine of $100, $100 public defender lien, $50 public defender application fee. Money's all ordered to be paid through the clerk's collection program at the rate of no less than $50 every month. You will have until March 1st of 2021 to make your first payment. Payments need to be made to the clerk of the court on the second floor of the courthouse. You can pay in person, you can pay by mail, or you can pay online. Your driving privileges are ordered suspended for a period of 6 months. The court has no objection to obtaining a business purposes license if you otherwise qualify. In case 20 CF 2115, you are judged guilty of possession of a controlled substance, sentenced to 120 days in the county jail with credit for 100 days that you've already served. That sentence will run concurrent with the sentence imposed in case 20 CF 2052. In order to pay court costs of $415, a $100 cost of prosecution, a fine of $100, $100 public defender lien, $50 public defender application fee, all through the clerk's collection program at the rate of no less than $50 per month. Payments are to run consecutive to the payments ordered in case 20 CF 2052. Your driving privileges are ordered suspended for a period of 6 months. The court has no objection to obtaining a business purpose license if you otherwise qualify. The court further has no objection to the driver's license suspension periods running concurrent with each other as to each of these cases. You have 30 days within which you can appeal the judgments and sentences that were just entered. If you want to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file a notice of appeal in writing within 30 days, you waive your right to appeal. Do you understand? Well, you can appeal the legality of the sentence that was just entered, and you can appeal this court's jurisdiction to hear your case. You cannot appeal your guilt or innocence of the underlying charges. Okay, thank you, sir. Good luck to you. All right, Christopher Minor.
Susan Kronk on behalf of Mr. Minor.
All right, good morning, sir. State your name. Okay, what's happening in Mr. Minor's case?
Your Honor, we are going to set this for a plea. If we could set it this week, but later in the week, Mr. Mendoza's covering for me. I'm actually on quarantine, so.
Okay. All right.
I just want to give him time to get to the jail and stuff.
Okay. Well, we got the jail feed again on Friday, I know. Well, it's going to be pretty busy, but...
I'll be ready by then.
Okay.
I know you said something about a Wednesday afternoon, Judge. Is that possible? Because this is a probation plea is what it looks like.
Well, we've got the jail feed tomorrow. I was asking about Wednesday, but we actually have it tomorrow afternoon. So if you think you could do it by then, we could.
Honestly, Judge, I know that I have something at 2 p.m. before you this afternoon. I'll go out to the jail once we're done with court, and I'll get it taken care of today.
Okay, excellent. Mr. Minor, we're going to set your case for tomorrow afternoon at 2 o'clock, and Mr. Mendoza will be in touch with you and go over the plea options that you have, sir. All right, thank you, sir.
Judge, I'm sorry. This afternoon?
No, 2 o'clock tomorrow.
He was saying he has something this afternoon.
Since I have this.
Oh, you can do it today?
Yeah, I could go to the jail after we're done in court.
Okay, so Mr. Minor, we can resolve your case this afternoon at 2 o'clock. Okay. Very well.
Thank you, Judge.
Thank you. Okay, we have Franklin Murnahan.
Richard Mendoza on behalf of Mr. Murnahan's cases.
All right, Ms. Murnahan, just a second. Let me get both your cases pulled up here. Ms. Murnahan, raise your right hand, please. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
State your name, please. Mr. Murnahan, in case 20 CF 2391, Mr. Mendoza has provided the court with a written plea form that indicates you wish to enter pleas of no contest to possession of heroin with intent to sell or deliver as charged in count 1, and unlawful use of a two-way communication device as charged in count 2. Is that what you wish to do, sir?
Yes.
Okay. Count 1 is a second-degree felony, punishable by up to 15 years state prison, 15 years probation, and/or a fine of up to $10,000. And it also carries a mandatory 6-month driver's license suspension. Count 2 is a third-degree felony, punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Do you understand?
Yes.
Okay. In case 20 CF 2445, the plea form submitted indicates you wish to enter pleas of no contest to delivery of methamphetamine as charged in count 1, and delivery or possession with intent to deliver or manufacture drug paraphernalia as charged in count 2. Is that what you wish to do in that case?
Yes.
Count 1, excuse me, yes, count 1 is a second-degree felony punishable by up to 15 years state prison, 15 years probation, and/or a fine of up to $10,000. Count 2 is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Do you understand?
Yes.
All right. Mr. Murnahan, did you read and understand the written plea form, sir?
Yes.
Do you have any questions at all about anything that's written on the plea form?
You did mention the other cases being no prospect on that.
Well, we haven't gotten to that yet, but
Okay, I apologize.
that's all right. We'll address that in just a moment, but do you have any other questions about anything on the written plea form?
On the written plea form, inmate.com and everything, I've never been on probation. I had 5 years to complete the terms of the probation, Your Honor. And if so, can you be a little lenient on my first payment to the court file?
I'm not sure what you're asking.
If I have 5 years to complete all the terms of my probation.
Yeah, we'll set for whatever money that you owe, there'll be a payment, monthly amount that you'll need to pay. And that can start a little bit after you get out of jail. Is that the question?
Yes, sir.
Okay. Any other questions about anything on the plea form?
That's it, sir.
All right. Are you currently under the influence of any medication, other drugs, or alcohol?
No, sir.
Are you thinking clearly?
Yes, sir.
Has any person coerced or forced you to enter these pleas?
No, sir.
The recommendation is that you would be adjudicated guilty of all counts to which you are pleading, that you would be placed on 5 years of drug offender probation. It would be a condition of your probation that you enter and successfully complete the Transition House Substance Abuse Treatment Program. You'd be required to complete a total of 150 hours of community service. It would be a condition that you not return to the area of the offenses. You'd be required to pay a fine, court costs, public defender lien, and application fee, as well as cost of investigation. The probation will run concurrent as to each count in each case. And the state is, in exchange for your plea in these cases, is agreeing to file a no information in case 20 CF 2444. Is that your understanding of the agreement?
Yes, sir.
Okay. Anything further?
Judge, in case number 20 CF 244, state has filed no information.
Okay. All right.
Your Honor, it is a supervised probation. What I have signed is I got to change the drug offender probation. That's correct.
Well, based on these charges, if I accept your plea, I'm going to impose drug offender
I
probation.
didn't know if there was a difference. I was just asking.
There's not a huge difference, but there's more frequent drug testing is the primary difference.
And on the transition house, because I'm a veteran, do I have 5 years to complete that program? To enter that program?
No, sir. You'll be required to enter the program as soon as a space becomes available.
Okay.
And remain in the program until you successfully complete it.
Okay, great.
Okay. Any other questions about your agreement?
No, sir.
Okay. You've been represented by Mr. Mendoza in these cases. Are you fully satisfied with his representation of you? Do you believe it is in your best interest to enter these pleas?
Yes, sir.
You understand that if you are not a United States citizen, entering these pleas will subject you to deportation.
Yes.
If you at any time are sentenced to state prison in Florida, and if you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any sentence the court might impose, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand? All right. You do have the right to have a jury trial in each case. If you chose to go to trial, you're entitled to a separate trial in each case, and the jury in each case would only be aware of the case that they had before them and not be aware of the other case. You would have the right to be represented throughout your trial by your lawyer. You would have the right to confront and cross-examine witnesses who testified against you. You'd have the right to present witnesses and evidence in your defense. You are entitled to use of the court's subpoena power to require any witnesses you have to be present at your trials. You would have the right to testify yourself at trial, or you could choose not to testify. If you chose not to testify at your trials, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt, and you could not be found guilty of any crime unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt. You understand?
Yes.
By entering these pleas, you're giving up the rights we've talked about, as well as the other rights that are written on the plea forms, and there won't be a trial in either case. You also, by entering these pleas, are waiving your right to appeal any matters relating to these cases other than this court's jurisdiction to hear the cases and the legality of the sentences imposed. Do you understand?
Yes.
All right. And this was not a Veterans Court ultimate case, or?
No, sir.
Okay. All right, Mr. Murnahan, I find that you are alert and intelligent, that you understand the nature of the charges against you, you understand the penalties that you're facing, and you understand the rights that you're giving up by entering these pleas. I find that your decision to enter these pleas has been freely and voluntarily made, that you've had the advice of a competent lawyer in these cases with whom you tell me you're satisfied. I've read the arrest affidavit by Detective Morris in case 20 CF 2391, as well as the affidavit for arrest warrant by Detective Fawcett, excuse me, again by Detective Morris, I apologize, in case 20 CF 2445. Based on those affidavits, I find that there's a factual basis in each case upon which your pleas can be accepted. So I'll accept the pleas of no contest. And what's the time served, Madam Clerk?
And 20 CF 2391 is 110 days, and 20 CF 2445 is 104 days.
Okay. Mr. Mendoza, any objection to score sheet 38.2 total sentence points?
No, Judge. Actually, I have a new one here that Mr. Brady just gave. It's the same point, but I think the prior history zeroed out.
Okay. All right. All right. Well, then, based on this score sheet, it does not appear a PSI would be appropriate.
No, sir, it's not.
Or required. Anything further with respect to sentencing?
Yes, Your Honor. One last thing. As Mr. Murnahan had stated, Transition House is going to pick him up today once he's released. They would pick him up by 1 p.m. I know Your Honor has no control over what the jail does. I just wanted to make sure that it is placed on the record on behalf of my client.
Okay, and it's Okay. It's contemplated to be a total of 150 hours of community service, is that?
Yes, Judge, not 300.
Okay. All right, Ms. Murnahan, in case 20 CF 2391, you will be adjudged guilty of possession of heroin with intent to sell or deliver as charged in count 1, and unlawful use of a two-way communication device as charged in count 2. As to each of those counts, you'll be required to serve 110 days in the county jail with credit for 110 days time served. That will be followed by 5 years of drug offender probation as to count 1, and 4 years, 255 days drug offender probation as to count 2, which will run concurrent with each other. You'll be required as a condition of probation to enter and successfully complete the residential treatment program at the transition house. You'll be required to remain in the county jail until the transition house comes to pick you up. Mr. Mendoza indicates that they're ready to do that today. Hopefully they'll be able to get that accomplished. It is a condition of your probation that you remain in the transition house program until you successfully completed and that you comply with all the rules and regulations of that program while in the program. You're required to complete 150 hours of community service at the rate of no fewer than 8 hours every month, beginning no later than the second month following your completion of the transition house program. It's a condition of the probation that you not return to the area of the Dollar General store at 2220 Michigan Avenue in Kissimmee while on probation. You'll be required to pay court costs of $415, a $100 cost of prosecution, a fine of $250, $100 public defender lien, $50 public defender application fee. Money's ordered to be paid at the rate of no less than $50 per month, beginning no later than the third month following your completion of the transition house program. Your driving privileges are ordered suspended for a period of 6 months. As to count 1, the court has no objection to obtaining a business purposes license if you otherwise qualify. As to case 20 CF 2445, you are adjudged guilty of delivery of methamphetamine as charged in count 1, in delivery of or possession with intent to deliver or manufacture drug paraphernalia as charged in count 2. As to each of those counts, you'll be required to serve 104 days in the county jail with credit for 104 days time served. That'll be followed by 5 years supervised drug offender probation as to count 1, and 4 years, 261 days supervised probation as to count 2. Those probationary terms will run concurrent with each other and concurrent with the probation imposed in case 20 CF 2391. It is a condition of your probation that you enter and successfully complete the residential drug treatment program at the transition house. You'll be required to remain in the Osceola County Jail until picked up by the transition house for transportation to that program. It is a condition of your probation that you remain in the transition house program until you successfully complete it and that you comply with all rules and regulations of that program. You're required to pay court costs of $415, a $100 cost of prosecution, a fine of $250, $100 public defender lien, and $50 public defender application fee, all at the rate of no less than $50 per month, consecutive to the payments ordered in case 20 CF 2391. It will be a condition of your probation in case 20 CF 2445 that you complete the community service hours ordered in case 20 CF 2391 within the time period ordered in that case. If I did not indicate earlier, the probation in case 20 CF 2445 will run concurrent with the concurrent as to each count and concurrent with the probation imposed in case 20 CF 2391. It will be a condition of your probation that you not return to the area of the intersection of Lakeshore Drive and Kaiser Road in St. Cloud while on probation. And is there anything further with respect to the sentence?
No, Your Honor, thank you.
Mr. Murnahan, you do have 30 days to appeal the judgment and sentences were just entered. If you wish to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir?
Yes, sir.
Thank you, sir. All right, we have Kevin Nunez Ramos.
Your Honor, can we call his case lost, please?
Okay. We'll call that case in a few moments. All right, and we have Joshua Rubin. Morning, sir. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, nothing but the truth? Excuse me. Please state your name, sir. All right, Mr. Rubin, you have two cases here. Just one moment. Okay, Mr. Rubin, in case 19 CF 2285, you were placed on probation for aggravated assault, which is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and or a fine of up to $5,000. Do you understand, sir? You've been accused of violating your probation. It's alleged you violated Condition 5 by committing the offense of burglary in occupied conveyance. Do you understand that?
Yes, sir.
If you admit that you did willfully violate your probation can be revoked and terminated. You could be sentenced to up to 5 years state prison. Do you understand?
Yes, sir.
And do you wish to admit that you violated your probation as alleged?
Yes, sir.
Okay. In case 20 CF 2043, you are charged with burglary of an occupied conveyance, which is a second-degree felony punishable by up to 15 years state prison, 15 years probation, and or a fine of up to $10,000. Ms. Cronk has submitted a plea form which indicates you wish to enter a plea of no contest to the lesser included offense of burglary of a conveyance, which is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and or a fine of up to $5,000. Is that what you wish to do? All right. Did you read and understand the written admission and the written plea forms in these cases?
Yes, sir, I did.
Do you have any questions about anything on either of those forms?
No, sir.
Are you presently under the influence of medication or any other type of drug or alcohol?
No, sir.
Are you thinking clearly at this time?
Yes, sir.
Has any person coerced or forced you in any way to enter this admission and this plea?
No, sir.
The recommendation is that the court revoke and terminate your probation in case 19 CF 2285 and impose a downward departure sentence of 6 months in the county jail with credit for the time that you served, followed by 12 months of community control, followed by 24 months of supervised probation with the conditions that were previously ordered reimposed as conditions of the new period of community control and probation. And in case 20 CF 2043, your recommendation is you would be adjudicated guilty. Again, sentenced to a downward departure sentence of 6 months in the county jail with credit for the time you've served, followed by 12 months community control, followed by 24 months of supervised probation. There would be a fine, court cost, public defender lien, and application fee, as well as restitution if applicable. Is that your understanding of the agreement?
Yes, sir.
Is there anything that
I have the score sheet if you don't have one.
I've got one here. All right, Mr. Rubin, you've been represented by Ms. Cronk in these cases. Are you fully satisfied with her representation of you?
Yes, sir.
You believe it is in your best interest to enter this admission and this plea?
Yes, sir.
You understand that if you are not a United States citizen, entering this admission and this plea will subject you to deportation.
Yes, sir.
If you are sentenced to state prison at any time, and if you've ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any sentence a court might impose, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Yes, sir.
You have the right in case 20 CF 2043, which is the burglary of a conveyance charge. You have the right to have a jury trial to determine whether the state can prove that you committed that crime. If you chose to go to trial, at your trial, you would be presumed to be innocent. You could not be found guilty unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt. In case 19 CF 2285, you do not have the right to a jury trial, but you do have the right to a hearing before the judge without a jury to determine whether the state can prove that you did willfully violate your probation. If you chose to proceed to hearing, you could not be found guilty of any violation unless the state proved by the greater weight of the evidence that you did violate your probation as alleged. Do you understand?
Yes, sir.
At both the jury trial in the new case and the violation probation hearing on the older case, you would have the right to be represented throughout all proceedings by your lawyer. You would have the right to confront and cross-examine witnesses who testified against you. You would have the right to present witnesses and evidence in your defense. You are entitled to have the court order any witnesses you had be present at the violation probation hearing and at the trial so you can present their testimony to the finder of fact. You also have the right at each proceeding to testify yourself. At the jury trial in the new case, you have the absolute right to choose not to testify, and if you chose not to testify, have the jury instructed they could not consider the fact you chose not to testify as evidence of guilt. At the violation probation hearing, you could choose not to testify with respect to the allegation that you committed a new crime while on probation. You could be required to testify with respect to any non-criminal aspects of the allegations, that is, the fact that you were, in fact, the person placed on probation, as well as the conditions of your probation. Do you understand?
Yes, sir.
Do you have any questions about your right? By entering this admission and this plea, you're giving up the rights we've talked about, as well as the other rights that are written on the admission and plea form, and there won't be any further hearing or trial in either case other than a sentencing hearing, which we would conduct this morning. You also, by entering the admission and plea, are waiving your right to appeal any matters relating to these cases other than this court's jurisdiction to hear the cases and the legality of these sentences imposed. Do you understand?
Yes, sir.
All right, Mr. Rubin, I've read the arrest affidavit or booking report in case 20 CF 2043 by Deputy Smith. Based on that affidavit, I find that there's a factual basis in that case upon which your plea can be accepted. I find that your decision to enter this admission and this plea has been freely and voluntarily made. You've had the advice of competent counsel with whom you tell me you're satisfied. You understand the nature of the allegations and charges against you, the penalties you're facing, and the rights you're giving up by entering the admission and the plea. So I'll accept the admission of violation of probation in case 19 CF 2285 and the plea of no contest in case 20 CF 2043. Ms. Cronk, do you agree with the score sheet submitted with 63.8 total sentence points?
Yes, Your Honor.
Ms. State, you recommending a downward departure sentence?
Yes, Judge, this is a downward departure based on the employer's plea bargain.
All right. Madam Clerk, what's the time served in these cases?
On the BOP is 151 days, and on the new law is 141 days.
All right. Okay, Mr. Rubin, in case 19 CF 2285, I'll revoke and terminate your probation. You'll be sentenced to 151 days in the county jail with credit for 151 days time served. Excuse me, you'll be sentenced to 6 months in the Osceola County Jail with credit for 151 days time served. That'll be followed by 12 months of community control, this level 1 community control, followed by 24 months supervised probation. The court will reimpose as conditions of community control and probation all conditions previously imposed as conditions of probation, in this case, financial and otherwise. You will be required to pay the outstanding financial obligations of $605.62, plus a $100 public defender lien for representation in this proceeding. Money is ordered to be paid at the rate of no less than $50 per month, beginning no later than the third month of your community control. You're required to report to the probation office no later than 2:00 p.m. on the next business day following your release from the Osceola County Jail. In case 20 CF 2043, you are judged guilty of burglary of a conveyance as a lesser included offense as to count 1. You are sentenced to 6 months in the county jail with credit for 141 days time served, followed by 12 months of level 1 community control, followed by 24 months of state probation. The sentence will run concurrent with the sentence imposed in case 19 CF 2285. In order to pay court costs of $415, a $100 cost prosecution, a fine of $500, $100 public defender lien, $50 public defender application fee, all of which is payable at the rate of no less than $50 per month, consecutive to the payments ordered in case 19 CF 2285. If there is any money that remains unpaid when you complete probation, it's ordered to be paid through the clerk's collection program at that same rate beginning the first month following termination of your probation. The court will impose as conditions of this probation the conditions previously imposed as conditions in case 19 CF 2285. Which include no hostile contact with Stephen Grant Rubin, mental health evaluation and any recommended treatment, 75 hours of community service, random drug testing, requirement that you take any medication that may be prescribed for you in the dosage that is prescribed, that you otherwise not possess any alcoholic beverages or controlled substances. And that says to both cases. In both cases, the sentence imposed is a downward departure sentence imposed pursuant to the uncoerced plea agreement between yourself and the state. And again, you are required to report to the probation office no later than 2 o'clock p.m. on the next business day following your release from custody. Mr. Rubin, have you been on community control in the past?
No, sir. I was on 3 years probation in the past.
Okay. But just be aware that community control is essentially a jail sentence. It's just that your house or your residence is your jail. While on community control, you're required to be at your residence 24 hours a day, 7 days a week, unless you have specific permission to be at another location or going directly to or from another location. The community control supervisor will work out a schedule with you. You'll be allowed to go to attend your employment. You'll be allowed to go to church if you attend church. You'll be allowed to go to school if you go to school. You'll be allowed time to shop for groceries and do your normal daily activities. But it all has to be according to a schedule that will be worked out with you in advance by your community control supervisor. 24 hours a day, 7 days a week, your community control supervisor needs to know exactly where you are. If he or she doesn't, you're very likely in violation of community control. So the reason why I tell you this is community control is much stricter than probation. It's very difficult to fully comply with. You really need to pay attention, dot every I and cross every T. You understand?
Yes, sir.
The other reason I'm telling you that is, as you know, you score state prison right now. If you were to come back on a violation of community control or probation, and if it were proved that you did willfully violate your community control or probation, it's very likely that the next sentence would be a state prison sentence. So just be very careful. You have 30 days within which you can appeal the judgment and sentence which is entered in each case. If you wish to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal within 30 days of today's date, you waive your right to appeal. Do you understand?
Yes, sir.
All right. Thank you, sir. Good luck to you.
Your Honor?
Yes, sir. There is a release date. I can't tell you when that is. That will be, the jail calculates the time served and any credits you may have, gain time or good time. So it's possible you'll get out today. It's possible it'll be very shortly. I don't know. I can't tell you that. Thank you, sir. All right, Detron Vaughn. Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? Excuse me. State your name, sir. Mr. Vaughn, I've been given a plea form in case 20 CF 1194. The plea form indicates you wish to enter pleas of, well, this is not checked. Is this guilty or no contest, Ms. Cronk?
No contest, Your Honor.
All right.
No contest.
With your permission, I'll mark that on the plea form. Mr. Vaughn, I'm told you wish to enter pleas of no contest to grand theft of a motor vehicle as charged in count 1, and resisting an officer without violence is charged in count 2. In this case, is that what you want to do, sir? Okay. Count 1 is a third-degree felony, punishable by up to 5 years state prison, 5 years probation, and or a fine of up to $5,000. He does carry a driver's license suspension for the period of any sentence imposed by the court. Count 2 is a misdemeanor, punishable by up to 1 year in the county jail, 1 year probation, and or a fine of up to $1,000. Do you understand? Did you read and fully understand the written plea form? Do you have any questions about anything on the written plea form?
Will the plea be ran concurrent with other counties, correct?
Well, the agreement is the plea would run concurrent with any other sentence that you may be serving. If you have other cases in other counties that you haven't yet resolved, I can't order this plea to run concurrent with a sentence that has not yet been imposed, that would be up to the judge in the other county. Does that answer your question? Okay. Any other questions?
Your Honor, I just wanted to, I'm sorry.
Go ahead.
I just wanted to put on the record that he does have a private attorney in the other counties. He did say that those will also be concurrent, but just for the record, I have nothing to do with those cases either, so that will be between him and his attorney in the other counties.
Okay, so he's not yet been sentenced in the other counties?
No, Your Honor.
Okay. So, Mr. Vaughn, it's possible that the judge in the other counties will run any sentence in those counties concurrent with this sentence, but that'll be up to that judge, and your attorney can advise you with respect to that. But I can't run this sentence concurrent to a sentence that has not yet been imposed. Do you understand?
Yes, sir.
Okay. All right, any other questions about anything on the plea form? Are you thinking clearly at this time? Are you under the influence of medication or any other type of drug or alcohol?
No.
Has any person coerced or forced you to enter this plea? Your recommendation, according to the plea form, is that the court impose a downward departure sentence of 30 months in the Florida Department of Corrections with credit for the time that you've served. Again, this would run concurrent with any other sentence you may be serving at this time. As to count 2, you'd be sentenced to 14
1
days.
year, Your Honor.
Excuse me, 1 year. Okay, 1 year. Osceola County Jail concurrent with count 1. Be required to pay fine, court costs, public defender lien, and application fee, as well as restitution if applicable. And there would be the driver's license suspension for the period of the sentence. Is that your understanding of the agreement?
Yes, sir.
You've been represented by Ms. Cronk. Are you fully satisfied with her representation of you?
Yes, sir.
You believe it is in your best interest to enter this plea?
Yes, sir.
You understand that if you're not a United States citizen, entering this plea will subject you to deportation. If you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any prison sentence imposed by the court, you could be committed civilly for an indeterminate period of time, which could extend up to the rest of your life as a sexually violent predator. Do you understand? You have the right to have a jury trial in this case. If you chose to go to trial, at trial you would be presumed to be innocent. You could not be found guilty of any offense unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt. If you chose to go to trial, at trial you would have all the rights that are set forth on the written plea form that you signed. Those rights would include the right to be represented by your lawyer throughout your trial, the right to present witnesses and evidence in your defense, the right to have the court order any witnesses you had to be present at the trial, the right to confront and cross-examine witnesses who testified against you, the right to testify yourself, as well as the right to choose not to testify. And if you elected not to testify, the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. Do you understand? By entering a plea of no contest, you're giving up each of the rights we've talked about, as well as the other rights that are written on the plea form, and there won't be a trial in your case. You also, by entering the plea, are waiving your right to appeal any matters relating to this case, with the exception of the jurisdiction of this court to hear your case and the legality of the sentence imposed. Do you understand?
Yes, sir.
All right. All right, Mr. Vaughn, I have read the booking report or arrest affidavit by Deputy Delancey in the court file. Based on that booking report, I find that there's a factual basis upon which your plea can be accepted. I find that you are alert and intelligent, that you understand the nature of the charges against you, the penalties you're facing, as well as the rights you're giving up by entering the plea. I find that your decision to enter the plea has been freely and voluntarily made. You've had the advice of competent counsel with whom you've expressed satisfaction. I'll accept the plea of no contest. Ms. Cronk, do you agree with the score sheet with 100.2 total sentence points?
Yes, Your Honor.
And state you're recommending your downward departure sentence?
Yes, Your Honor.
Okay. Is restitution an issue?
No, Your Honor.
Okay. All right. Very well. Anything further to be said before sentence is imposed, Ms. Cronk?
No, Your Honor.
Okay. Ms. Vaughn, you will be at this time adjudged guilty of grand theft of a motor vehicle as charged in count 1 and resisting an officer without violence as charged in count 2. What's the time served? 184, okay. As to count 1, you will be sentenced to 30 months in the Florida Department of Corrections with credit for 184 days time served. Count 2, you'll be sentenced to 1 year in the Osceola County Jail with credit for 184 days time served. Those sentences will run concurrent with each other and concurrent with any other sentence you may presently be serving. This is a downward departure sentence imposed pursuant to the uncoerced plea agreement between yourself and the state. You're ordered to pay court costs of $415, a $100 cost prosecution. There will be a fine of $500, $100 public defender lien, and $50 public defender application fee. The money is ordered to be paid through the clerk's collection program at the rate of no less than $50 per month. You'll have until August 1st of 2022 to make your first payment. Your driving privileges are suspended pursuant to Florida Statute 322.274 for the period of time of the sentence. Mr. Vaughn, if you do get additional time in another county or other counties, and you will be incarcerated close to the time where the payments are to start, just contact the court or contact Ms. Cronk. We'll start the payments about 60 to 90 days following your release from custody. You have 30 days within which you can appeal the judgment and sentence was just entered. If you wish to appeal and you're unable to afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand?
Yes, Your Honor.
All right, thank you, sir. You too. So as to Mr. Baxter Rios, I don't see a plea form. Is that resolved this morning? Or am I looking at this afternoon already? I am. I'm sorry, that's at 2 o'clock.
Yeah, that is.
Okay, so I think then we have one more case here. That'd be Mr. Nunez Ramos.
And then Serrano Santiago.
Sorry?
And Serrano Santiago.
Okay. What's happening with Kevin Serrano Santiago?
Your Honor, it'd be a change of plea. I think I had submitted a plea form.
You did. Okay. Kevin Serrano Santiago, if you'll please come forward. Folks, I'm sorry we had you come here at 8:30. For those of you with folks next door, I apologize. That's my fault. Mr. Serrano Santiago, if you'll raise your right hand. Your other right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I'm sorry? You don't know? Okay. Are you thinking clearly at this time? Okay. Well, I'm not going to take the plea of Mr. Serrano Santiago at this time. We can reset that. We may need to have him brought over. Whose case is this yours, Mr. Miller?
This is both our cases, Judge.
Sorry?
With Mr. Mendoza and with me.
Are there issues that need to be addressed here?
Judge, I'm not sure.
What I guess I recommend is potentially Friday, if we have the jail feed on Friday.
All right, we'll reset Mr. Serrano Santiago to Friday, December 11th at 8:30.
Yes, Your Honor. Mayor, would you get the plea form?
Yes, I just gave the clerk. Okay. All right, Kevin Nunez Ramos.
Your Honor, is it possible?
It's $90.
No, I'm afraid there's very limited crew there, but I'm afraid we've got to announce what's what. Morning, Mr. Nunez-Ramos. If you'll please raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Tell us your name, please. All right, Mr. Nunez-Ramos, you are here in 2 cases. Yes, sir. Well, in order to make the record, I need to announce your charges. We can pass it for one moment if they're ready to move the other folks out. I want the inmates taken out except for Mr. Nunez-Ramos, if we can.
Judge, Mr. Pantojas is my case. We're not ready to plea today. We were set for a plea status. If we could reset that for Friday, and then the rest of it. We're
resetting Mr. Pantojas for Friday, the 11th. So those folks should all be ready to go.
Thank you, Judge.
All right, so we'll start over. Mr. Nunez-Ramos, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, nothing but the truth?
Yes, sir.
State your name, sir. Okay.
Serena Hernandez Defense.
Mr. Nunez-Ramos, you're here in 2 cases. In case 13 CF 2846, you were placed on probation for sexual activity with a child by a person in familial or custodial authority, which is a first-degree felony punishable by up to 30 years state prison, up to 30 years probation, and or a fine of up to $10,000. Do you understand? Been accused of violating your probation. It's alleged that you violated Condition 5 by committing the offense of failure to report email address or internet identifier on or about June 16th of 2020 here in Osceola County. It's alleged you violated Condition 7 by unlawfully possessing or consuming a controlled substance without a prescription, specifically K2, also on or about June 16th of 2020. Do you understand what the allegations are, sir?
Yes, sir.
If you admit that you willfully violated your probation can be revoked and terminated. You could be sentenced to up to 30 years state prison. Do you understand? And do you wish to admit that you violated your probation as alleged? Do you wish to admit that you did willfully violate your probation as alleged? Okay. All right. You're also here in case 20 CF 1728, in which a plea form has been submitted, which indicates you wish to plead guilty to false registration by a sexual offender as charged. Is that what you wish to do? That charge is a 3rd-degree felony, punishable by up to 5 years state prison, 5 years probation, and or a fine of up to $5,000. Do you understand? All right. Mr. Nunez-Ramos, did you read and understand the written plea form as well as the written admission form? Do you have any questions about anything on either of those forms? Are you currently under the influence of medication or any other type of drug or alcohol? Are you thinking clearly at this time? Did any person coerce, pressure, or in any way force you to enter this admission and this plea? The recommendation in these cases is as follows. In case 13 CF 2846, the recommendation is that the court revoke and terminate your probation, impose a downward departure sentence of 9 years in the Florida Department of Corrections. You'll be required to pay any outstanding financial obligations plus a $100 public defender lien in that case. Is that your understanding of the agreement in that case? In case 20 CF 1728, the recommendation is that the court judge you guilty of the crime to which you are pleading, that you be sentenced to 41.25 months in the Florida Department of Corrections, which again would be a downward departure sentence, that would run concurrent with the sentence in the other case. There'd be a fine, court cost, public defender lien, and application fee. Is that your understanding?
Yes, sir. I have a question on the 41 points. How much are you?
I'm sorry?
The 41 point something on the 20 CFA. How much are you?
He wants to know how
What's the time served? Is how many what?
He wants to know how many years is 41.25. Is that correct, Mr. Nunez?
Let's be about 3.5 years.
That's going concurrent with the nomination.
That's what the agreement is, yes, sir.
Thank you.
Any other questions?
No, sir.
All right. Well, to be precise, it'd be 3 years, 5.25 months. Okay. All right, Mr. Nunez Ramos, you've been represented by Ms. Hernandez in these cases. Are you fully satisfied with her representation of you? Do you believe it is in your best interest to enter this admission and this plea?
Yes, sir.
Do you understand that if you are not a United States citizen, entering this admission and this plea will subject you to deportation?
Yes, sir.
Based on your prior criminal history, once you complete any prison sentence that the court imposes in these cases, you could be subject to a civil commitment under the Jimmy Rice Act as a sexually violent predator. If that civil commitment were to occur, it would be for an indeterminate period of time, which could extend up to the rest of your life. Do you understand? All right. Mr. Nunez Ramos, you have the right in case 13 CF 2846, which is the violation of probation case, to have a hearing without a jury to determine whether the state can prove that you did willfully violate your probation. If you chose to proceed to hearing, you could not be found guilty of any violation unless the state proved by the greater weight of the evidence that you did violate your probation as alleged. Do you understand?
Yes.
In case 20 CF 1728, the new case, the false registration charge, you have the right to have a jury trial to determine whether the state can prove that you committed that crime. If you chose to go to trial, at your trial, you would be presumed to be innocent, and you could not be found guilty unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt. Do you understand?
Yes.
At both the jury trial on the new case and the violation of probation hearing on the older case, you would have the right throughout all proceedings to be represented by your lawyer. You would have the right to confront and cross-examine witnesses who testified against you. You would have the right to present witnesses and evidence in your defense. You are entitled to have the court order any witnesses you have to be present at your trial and at the violation probation hearing. You also would have the right at each proceeding to testify yourself. At the jury trial in the new case, you have the absolute right to choose not to testify, and if you chose not to testify, you have the right to have the jury instructed they could not consider the fact you chose not to testify as evidence of guilt. At the violation probation hearing, you would have the right to choose not to testify with respect to any allegation you committed a new criminal offense while on probation, you could be required to testify with respect to other matters. Do you understand? Do you have any questions at all about your rights? By entering this admission and this plea, you're giving up all the rights we've just talked about, as well as the other rights that are contained on the written admission and plea forms that you sign. You also, by entering this admission and plea, are waiving your right to appeal any matters relating to this case, except for the legality of the sentence imposed in this court's jurisdiction to hear the case. And by entering this admission and plea, there will be no further trial or hearing in either case other than a sentencing hearing. Do you understand? All right. All right, well, Mr. Nunez-Ramos, I've read the arrest affidavit or booking report in case 20 CF 1728 by Deputy Lincourt. Based on that affidavit, I find there's a factual basis in that case upon which your plea can be accepted. I'll accept your plea of guilty in case 20 CF 1728. I'll also accept your admission of violation of probation, case 13 CF 2846. Mr. Hernandez, do you have any objection to the score sheet with 236 total sentence points?
No, Your Honor.
In state, you recommend a downward departure sentence?
That's correct, Your Honor.
Is there anything further with respect to sentence in either case?
Nothing further.
Okay. Mr. Nunez-Ramos, in case 13 CF 2846, I will revoke and terminate your probation. You'll be sentenced to 9 years in the Florida Department of Corrections with credit for the 235 days that you've served since your release from the Department of Corrections, as well as all time previously credited towards your initial Department of Corrections sentence. That'll be calculated by the Florida Department of Corrections so that 235 is from the date on the arrest of the VOP. Okay. This is a downward departure sentence imposed pursuant to the uncoerced plea agreement between yourself and the state. So it's 9 years less the 235 days you've served since your release, less the time that was previously credited towards that initial prison sentence. In order to pay the outstanding financial obligations of $409.39 plus a $100 public defender lien for representation in this proceeding, money is ordered to be paid at the rate of no less than $50 per month through the clerk's collection program. You'll have until February 1st of 2027 to make your first payment. In case 20 CF 1728, you are judged guilty of false registration by a sexual offender. You're sentenced to 41.25 months in the Florida Department of Corrections with credit for 175 days that you've served in that case. That sentence is a downward departure sentence imposed pursuant to the uncoerced plea agreement between yourself and defense, or yourself and the state. And the sentence will run concurrent with the sentence imposed in case 13 CF 2846. In order to pay court costs of $415, a $100 cost of prosecution, a fine of $500, $100 public defender lien, $50 public defender application fee, all through the clerk's collection program at $50 per month. The payments be consecutive to the payments ordered in case 13 CF 2846. Is there anything further with respect to the sentences?
Nothing further, Your Honor.
Okay. Mr. Nunez-Ramos, you have 30 days within which you can appeal the judgments and sentences that were just entered. If you wish to appeal and you cannot afford to hire a lawyer, I will appoint one to represent you. If you do not file a notice of appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir?
Yes, sir.
Yes, sir.
So, on the case of 13 CF, are they counting 3 years already served in prison?
They're counting the days that you actually served You don't get credit for any time that you didn't serve. So if you received early release credits of any kind, good time, gain time, anything of that nature, those dates would not count. So it doesn't come out to exactly 3 years unless you served day for day of the 3 years it was originally imposed.
And the case number 20 CF, the time that I was 5 years?
Yeah, it's 175 days since your arrest on that.
So 175 and then 265.
It was 235.
235, Your Honor.
235 on the violation of probation case, in addition to the time that was credited towards that 3 years. No, 175 is in the other case. One case you got 41.25 months with credit for 175 days. That's all on the new case. The old case, you got 9 years with credit for the 235 days you served since your arrest on the violation probation, plus credit for all the time you previously served in the county jail and the Department of Corrections on that original 3-year sentence. Thank you, sir. Okay, we'll switch over and get you guys moving. I'm sorry for I always do that when I set the calendar myself. I always screw it up and leave you guys in alert. So. You have your cousin Jack. Okay. Okay, we have Jack Lindsay, if you want to come on up. All right, good morning, sir. State your name, please.
Jack Lindsay.
Okay, Mr. Lindsay is here in case 15 CF 1380. And this.
Hi. Good afternoon, Osceola County Corrections. Can you hear me okay?
Yes, Your Honor, we can hear you. This is Ben King with the Public Defender's Office.
It's Mr. King, is that correct?
Yes, Your Honor. We're good to go over here whenever you're ready.
All right, thanks. All right, and who do I have? I have Mr. Moffitt from the state.
Yes, Your Honor. Edwin Moffitt for the state.
Thank you. And Officer Kendo.
Yes,
welcome. All right, for everyone out at the jail facility, I know that you've watched a little video, been given some information about initial appearances and may have had an opportunity to speak with Mr. King briefly this afternoon. My name is Keith Carson. I'm one of your circuit judges, and today is initial appearances. Each of you were arrested based on allegations in a charging affidavit. I have read all of those charging affidavits. I will make a determination as to whether taking those facts as true, which I must at this point, there establishes probable cause. Then we'll talk about getting an attorney on board for you, and after that we'll talk about conditions of bond that are appropriate, if any, that can get you back to your lives while these cases are pending. I know many of you may disagree with the allegations in your charging affidavit. It's very unlikely I'm your trial judge. It's not an appropriate forum today to talk about any disagreements with the facts of those allegations. You need to save that for discussions with your attorney and your trial judges. I've got a number of cases that are Spanish-speaking clients, so I'm going to get the interpreter on board, and we're going to do those cases first.
Yes, Your Honor, I have a list if you need them.
I think Mr. Arce Rodriguez, Mr. Diaz-Gomez, and Mr. Garcia-Roman, correct?
Correct, that's all.
All right, let me get the interpreters on board.
Thank you, sir.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Good afternoon, Mr. Leal. We are here for initial appearances. All of the clients will be out at the jail facility. You'll be doing your interpreting over the intercom system. The first case that I have for you is Mr. Arce Rodriguez. He has two case numbers, 2020 CF 3538 and 2020 MM 2925. Mr. Arce Rodriguez, you can come on up to the podium, please.
Puede acercarse al podio, señor Arce Rodríguez.
Good afternoon, sir.
Buenas tardes, señor.
Is his microphone on?
El micrófono no está prendido.
¿Me escucha ahora?
Buenas tardes, señor.
Buenas tardes.
Good afternoon.
Mr. Arce Rodriguez, you were arrested based on an allegation in 2020 CF 3538 that has 4 counts.
Señor Rodríguez, usted ha sido arrestado basado en una acusación en el caso 20 BS CF 3538 que tiene 4 cargos. Yes.
The first count is fleeing or attempting to elude a law enforcement officer at high speed.
El primer cargo es tratar de eludir a un oficial de la fuerza pública a alta velocidad.
The second allegation is driving while license suspended with knowledge.
El segundo es manejar con licencia suspendida a sabiendas.
The third allegation is operating a motor vehicle without a motorcycle license.
La tercera, manejar un vehículo sin tener la licencia de motocicleta.
And there is a second case in 2020 MM 2925 that alleges that you resisted an officer without violence.
Y hay un segundo cargo dentro del caso 20MM 2925 que acusa de que se resistió a un oficial de la fuerza pública sin violencia.
Court will appoint the Office of the Public Defender to represent your interests.
Así que el tribunal va a consignar a la Defensoría Pública para que represente su causa.
I have read the charging affidavit and find probable cause.
Vi el escrito de acusación y determino que hay indicios de culpa.
I do not find pretrial release is appropriate under your facts.
Debido a esta circunstancia, no creo que sea apropiada una libertad provisional.
Court will set bond in count 1 in the amount of $5,000.
El cargo número 1, la corte impondrá $5,000 de multa. Perdón, de fianza.
Count 2 in 2020 CF 3538 and count 3 will be set in the amount of $500 each.
En los cargos 2 y 3 del CF 3538 serán $500 cada uno.
And the sole count in 2020 MM 2925, the court finds probable cause and sets bond in the amount of $500.
Y en el otro caso, el caso 20MM 2925, que es una sola causa, determina que hay indicio de culpa e impone $500 para salir bajo fianza.
As a condition of your bond, you are not to operate a motorcycle without a valid license.
Como condición de su fianza, no puede andar en motocicleta hasta que no tenga licencia.
Any court dates, Madam Clerk?
Yes. On case 20 MM 2925, next court date December 17, if still in jail, or January 8 at 8:15, if released.
En el caso M2925, si está todavía en la cárcel, La próxima vista será el 17 de diciembre. Y si ha salido, entonces sería para el 8 de enero a las 8:15.
Thank you, sir.
Gracias, señor.
John Diaz Gomez.
Be approved.
Good afternoon, Mr. Diaz Gomez.
Buenas tardes, señor Díaz Gómez. Good afternoon.
Mr. Diaz Gomez, you were arrested based on an allegation of battery, domestic violence related on a pregnant woman.
Señor Díaz Gómez, a usted lo arrestaron basándonos en una acusación que hay de una acción de agresión física, un hecho de violencia intrafamiliar en contra de una mujer embarazada.
I find probable cause for your initial arrest.
Veo que hay indicios de culpabilidad por su arresto inicial.
We have a witness present.
Tenemos aquí un testigo presente.
May I have your name, please?
Su nombre, señora.
Angie Flores.
Angie Flores.
Do you need the assistance of an interpreter?
¿Necesita intérprete?
Señor.
Do you need the assistance of an interpreter?
¿Necesita la ayuda de un intérprete?
Sí.
Yes.
All right. Thank you. Let's swear you in, ma'am.
¿Va a prestar juramento, señora?
Do you solemnly swear or affirm to testify the truth and nothing but the truth to help you God?
¿Jura afirmar que va a testificar la verdad y nada más que la verdad? ¿Lo jura ante Dios?
Sí, señora, lo juro.
Yes, ma'am, I do.
And what is your relationship to Mr. Diaz Gomez?
¿Y qué relación tiene usted con el señor Díaz Gómez?
Es mi esposo.
He's my husband.
And it is alleged that you were the victim in this criminal allegation. Is that correct?
Y se presume que usted es la víctima en esta acusación. ¿Es eso correcto?
Sí, señor.
Yes, sir.
The court will be considering conditions of bond this afternoon. Would you like me to have any information in making that determination?
Así que el tribunal va a tratar de determinar las condiciones para dar libertad bajo fianza. ¿Hay alguna información que usted me quiera dar en particular para tomar yo en cuenta a la hora de dar la salida bajo fianza?
Sí, señor. Yo reconozco que actué bajo ira y me dejé llevar por mis impulsos.
Yes, sir. I admit that I was taken away by my own anger and I let my impulses get the better of me.
If the court were to consider contact with Mr. Diaz Gomez, do you wish to have contact with him?
Y si el tribunal entonces quiere tomar en cuenta permitir contacto entre usted y el señor Díaz Gómez, ¿a usted le gustaría que tenga contacto con él?
Sí, señor. Deseo retirar los cargos.
Yes, sir, and I wish to withdraw any charges.
If the court were to consider allowing contact, do you have any fear of Mr. Diaz Gomez?
Y si la corte decidiría que va a permitir contacto, ¿usted tiene algún temor al señor Díaz Gómez?
No, ninguno.
No, none.
It was reported that there have been prior incidents of violence. Did you give that information to the police?
Se reportó que habían incidentes anteriores de violencia. ¿Usted le informó eso a la policía?
En ningún momento ha sido la primera vez.
At no point. This has been the first time.
Do you possess a cell phone, or is there a phone at the home that you could contact law enforcement in the future?
¿Usted tiene el celular o hay algún teléfono en su casa para que usted, si es necesario, llame a la fuerza pública?
Sí, yo cuento con teléfono.
Yes, I do have a phone.
Who else resides in the home?
¿Y quiénes más viven en su residencia?
Vivimos con mi hijo y un amigo de nosotros.
We live with a son and a friend of ours.
How old is your son?
¿Qué edad tiene su hijo?
12 años.
12 years old.
Are you concerned regarding any issues of violence between Mr. Diaz Gomez and your 12-year-old son?
¿Y tiene alguna preocupación o inquietud de que pudiese haber violencia entre el señor Díaz Gómez y su hijo de 12 años?
No, no, señor, ninguna.
No, no, sir, not at all.
Mr. Moffitt, does the state have any questions of this witness?
¿Pregunta de la fiscalía?
No additional questions, Your Honor. Thank you.
No más preguntas, señorías.
Mr. King, any questions of this witness?
Just a couple, Your Honor, please. Thank you. Ma'am.
Son un par de preguntas, gracias.
Ma'am, do you want to have contact with Mr. Diaz-Gomez?
Señora, ¿usted quiere tener contacto con el señor Díaz Gómez?
Sí, señor.
Yes, sir.
Do you want him to return to your home?
¿Usted quiere que vuelva a su residencia?
Sí, señor.
Yes, sir.
You don't have any fear of him?
¿Y usted no le tiene ningún temor a él?
No, ningún temor.
No, no fear.
If you were to be afraid that he would do something against the law to you in the future, would you take steps for your safety, such as calling the police?
Si en algún momento usted temiese que va a cometer algún acto ilegal en contra suya, ¿usted tomaría los pasos necesarios para protegerse usted misma, como por ejemplo llamar a la policía si fuera necesario?
Sí, señor.
Yes, sir.
Thank you, ma'am. That's all.
Gracias, señora. Eso es todo.
Muchas gracias.
Thank you very much.
Moffitt, any additional information from the state?
¿Más información de la fiscalía?
No additional information, just pointing out to the court in the affidavit that it does note that there were prior incidents and the victim testified that there were no other incidents today.
No, únicamente la información es que en el affidavit decía que había algunos incidentes anteriores.
Thank you.
Gracias.
Ma'am, you are in the best possible position to gauge whether you believe you are in fear of Mr. Diaz-Gomez for either yourself or your children.
Señora, usted realmente está en la mejor perspectiva para determinar si tiene algo que temer o alguna preocupación en referencia a las acciones del señor Díaz Gómez o la protección de su niño.
Based on you appearing in court, I take your statements to be true.
Basado en su comparecencia ante el tribunal, yo pienso que sus declaraciones son ciertas.
The court is going to set bond for Mr. Diaz-Gomez in the amount of $2,500.
El tribunal va entonces conceder una fianza para el señor Díaz Gómez de $2,500.
As a condition of his bond, he's to have no hostile contact with you.
Como condición de esa libertad bajo fianza, él se le prohíbe tener contacto con hostilidad con usted.
Mr. Diaz-Gomez, no hostile contact means you may not be hostile with Ms. Diaz-Gomez, and obviously you may not put your hands on her without her permission.
Y señor Díaz Gómez, obviamente el contacto es sin hostilidad. O sea, usted no le puede poner una mano encima a ella sin autorización de ella.
Court will allow you to return to the family home.
La corte le permitirá que regrese al seno familiar.
If I did not previously appoint the Office of the Public Defender, I'll do so now.
Yo no había designado a la Defensoría Pública, creo, pero voy ahora a designar al Defensor Público.
I note Mr. Diaz-Gomez may have some immigration issues, and I'm not sure whether this will effectuate his release or not.
Que sepa que quizás el señor Díaz Gómez tenga problemas de inmigración, pero yo no sé si este problema va a afectar su estatus o no.
Anything further from the state?
¿Algo más de la Fiscalía?
No, Your Honor.
Anything further from defense?
¿De la defensa?
No, thank you, Your Honor.
No, gracias, señor. Gracias.
That will complete our hearing.
Con eso concluye nuestra audiencia.
Thank you. One more case for you, Mr. Leal. It is Garcia Roman. He has a number of cases, 2020 CT 3214, 3216, and 3217, and 2020 CT 558.
Thank you, Your Honor.
Good afternoon, Mr. Garcia Roman.
Buenas tardes, señor García Roman. Buenas tardes. Good afternoon.
Mr. Garcia Roman, you have 4 cases or 4 counts in 2 different cases.
Usted tiene 4 cargos en 2 casos diferentes.
You are charged with operating a motor vehicle without a valid driver's license.
Una manera un vehículo sin tener licencia válida de conducir.
Attaching a tag not assigned to the vehicle.
Colocar una placa al vehículo que no le corresponde.
Driving with no motor vehicle registration.
manejar sin matrícula de vehículo,
and failing to appear in case number 2020 CT 558.
y tener una incomparecencia a una cita judicial en torno al caso 2020 CT 558.
On 2020 CT 558, Judge Epperson issued a bond for failing to appear in the amount of $250.
Por no comparecer en esa causa 2020 CT 558, el juez Epperson puso $250.
As to the cases in 2020 CT 3214, 3216, and 3217, the court finds probable cause.
En cuanto a los casos 2020 CT 3214, 3216 y 3217, el tribunal ha determinado que hay indicios de culpa.
Court will issue a bond in each count of those cases in the amount of $500 each.
La Corte va a dar una fianza en cada uno de los casos de $500 bajo fianza por cada caso.
I will appoint the Office of the Public Defender to represent your interest.
Y voy a designar la oficina de la Defensoría Pública para que represente sus intereses legales.
Thank you, sir.
Gracias, señor.
Gracias.
Thank you.
Mr. Leal, I believe that's all the business we have for you this afternoon. Thank you for your help.
You're very welcome, Your Honor.
Bo Carrier. Is he qualified? Good afternoon, Mr. Carrier. Mr. Carrier, you were arrested based on an allegation of battery on a pregnant woman. The court has read the charging affidavit. I do find probable cause for the allegation. The court's going to set a bond in your case in the amount of $2,500. You're to have no contact with the victim in this case, and that would be Miss Nina Ann DePirio. You're not to return to the Evergreen Street address. Do you have personal belongings there?
Yes, sir.
Court will allow you to return one time with law enforcement to get some personal belongings until this gets sorted out. As a standard condition of your bond, you're not to possess any weapons or firearms. As a condition of your bond, you're not to consume any alcohol or any illegal substances. I will appoint the Office of the Public Defender to represent your interests, and we're going to give you a new set of court dates. Do we have any new court dates for this?
No, I'm in.
Okay. Got no additional court dates for you. Stay in contact with your attorney. Thank you.
Thank you.
Michael Concepcion. Good afternoon, sir.
Good afternoon.
Will you spell your last name for us, sir?
Yeah, it's CONCEPCION.
All right, thanks. I think we were missing a C on our paperwork. Is it pronounced Concepcion?
It's Concepcion.
Can't roll my R's very well, but I guess there's no R's in there. You are alleged to have committed battery, domestic violence related. I have read the charging affidavit. I do find probable cause for your initial arrest. We do have a witness present. Good afternoon, sir.
How are you doing?
And we're going to swear in our witness, please.
Raise your right hand, please.
Do you solemnly swear or affirm to tell the truth and nothing but the truth, so help you God?
Yes.
Sir, your name, please.
O'Neill Torres.
All right. Thank you, Mr. Torres. I will be considering conditions of bond for Mr. Concepcion. Do you wish to be heard as to that consideration?
Yes.
All right. When you're ready.
Yeah, I just want to drop the charges.
Okay.
And just want to see that everything's taken care of properly, you know, and what will be the next steps for that.
Understood.
Your Honor, could we have the gentleman speak into the microphone, please?
Yeah, he's at a button microphone, and it's pretty difficult. I need you to talk nice and loud, that little tiny
I'd
microphone.
like to drop the charges, and what will be the next steps after that?
All right, thank you. A representative from the Office of the State Attorney is present. They are the one who moves forward with prosecution or not. The court doesn't have any ability to dismiss the charges at this point. but your wishes have been noted by the Assistant State Attorney who is present. Should the court consider conditions of bond for Mr. Concepcion, do you wish to have contact with Mr. Concepcion?
Yes, that's fine.
All right. Thank you. And do you have any fear of further violence between you and Mr. Concepcion?
No.
Has there been issues of violence in the past?
No.
Do you cohabitate? Do you live together with Mr. Concepcion?
Yes.
Right. Thank you. Any follow-up questions, Mr. Moffitt? No additional questions. Mr. King, any questions?
Yes, Your Honor. Sir, you don't have any fear of Mr. Concepcion?
No, sir.
You wish to have contact with him?
Yes.
You wish to have him return to your home?
Yes.
If you were to become afraid of him in the future, for any reason that he would violate the law, would you call the police or take steps to protect your safety?
Of course.
That's all, Your Honor.
All right. Thank you. Thank you very much for the testimony.
Thank you.
Mr. Concepcion, the court is going to grant bond in the amount of $500 plus pretrial release conditions. You're to have no hostile contact with the victim in this case. No hostile contact means exactly what it sounds like. The court will allow you to cohabitate with the victim while this case is pending. And I will appoint the Office of the Public Defender to represent your interests if not previously appointed. Thank you, sir. Marlon Curtis. Good afternoon, Mr. Curtis.
Good afternoon, Your Honor.
Mr. Curtis, you were arrested based on an allegation of petty theft, third or subsequent offense. I read the charging affidavit. I do find probable cause. I'll appoint the Office of the Public Defender to represent your interests. The court is going to release you on straight pretrial release with an added condition that you be drug tested for any drugs in your system while you are on pretrial release. They'll give you some guidance as to when you need to come in to test. Any positive test would be could be seen by your trial judge as a violation of your pretrial release conditions and result in your arrest. Do you understand?
Yes, Your Honor.
All right.
Judge, can you order the defendant not to possess or consume any illegal drugs?
Yes, Mr. Curtis, you're ordered not to possess or consume any illegal substances as a condition of your bond.
Yes, one final request, Your Honor, no return to the location of the offense.
Yes, the state's request will also be granted, and you can't go back to the Best Buy. Thanks.
Public Defender's Office appointed?
Yeah, I think I had appointed them.
Okay, I didn't hear. Thank you, Your Honor.
No worries. Brian Davis.
Brian Davis?
Good afternoon, Mr. Davis. Mr. Davis, you were arrested based on an allegation of battery, domestic violence related, and false imprisonment. Read the charging affidavit. I do find probable cause for your initial arrest. The court is inclined to set bond in your case. I'm going to set bond in count one in the amount of $500 with pretrial release conditions. Those pretrial release conditions are that you may not have contact with the victim or the alleged victim in this case, and you may not return to the location, which seems to be the family home. I would assume you've got some personal belongings there?
That's correct. I actually don't have my cell phone or anything. It was left there.
Okay. All right. The court will allow you to return one time with law enforcement to get all the stuff you need to tide you over until the case gets worked out. As to count two, the court does find probable cause bond, and that count will be set in the amount of $500. And if I didn't announce it, the Public Defender's Office is appointed to represent your interests.
Thank you.
Thank you, sir. Christopher Gonzalez. Good afternoon, Mr. Gonzalez. Mr. Gonzalez, you were arrested based on an allegation of fleeing a law enforcement officer with lights and sirens active. Count two is no motor vehicle registration. Count three is operating a vehicle without a valid driver's license. I do find probable cause for that initial arrest. Bond in count 1 is going to be set in the amount of $3,500 as to count 2 in the amount of $500 as to count 3 in the amount of $500, and I will appoint the Office of the Public Defender to represent your interest.
Thank you.
Rodrigo Granda?
Your Honor, this individual is detoxing.
Okay, we'll reset Mr. Granda for tomorrow.
Thank you.
Mahogany Harris?
Ms. Harris?
PD approved.
Thank you, ma'am.
Good afternoon, Ms. Harris. Ms. Harris, you were arrested based on an allegation of false imprisonment and battery domestic violence. I read the charging affidavit. I do find probable cause for your initial arrest. In the new case, 2020 CF 3545, the court is going to grant bond in count 1 in the amount of $500 is to count 2 in the amount of $500 plus pretrial release. Well, you can't take her, can you?
She doesn't qualify, Judge. She's out on bond.
All right. Count 2 is going to be $500 with conditions of bond being that you have no contact with, is this Dad? No. Mark Petit Frere. You have no contact with Mark Petit Frere, and you not return to the location where they took place, which is the Hidden Palm Circle address. Court will appoint the Office of the Public Defender on your new case, 2020 CF 3545. The court has probable cause to believe that that there is probable cause found for a new felony offense while new felony offense while you were out on bond in 2020 MM 1015. The court's going to revoke your bond in that case.
That will be 1615.
Your Honor, if I may address one of the pretrial release conditions.
Sure.
Ms. Harris is telling me that Mr. Petit Frere does not live at that address and that she is the only one that resides there.
Court's going to amend the condition of bond that they're not to cohabitate together. If Ms. Harris, if that gentleman is there, you may not be there. Regardless of whether he lives there or not. If he's in that apartment, you are not to be there.
Okay. Thank you.
However, you, as I was explaining, you're out on bond on another case. I'm going to revoke your bond, set bond the amount of none, and you're going to need to go before Judge Arendis to determine a reasonable bond amount in 2020 MM 1615 based on your new arrest. I'll appoint the Office of the Public Defender on that case as well if they weren't previously appointed.
Thank you.
Yes, yes, may not cohabitate would be the condition of bond.
So would that be separate residence, Judge?
Yes, they are to maintain separate residences. Thank you. Sorry about that. All right, that will conclude our hearing.
Good luck.
Thank you, ma'am. Aaron Hollier.
Mr. Hollier.
Good afternoon, Mr. Hollier.
Good afternoon.
Mr. Hollier, you were accused of carrying a concealed firearm, possessing a controlled substance without a prescription, and possession of drug paraphernalia in 2020 CF 3546. I read the charging affidavit. I do find probable cause. The court's going to release you on pretrial release. They're going to need a stable address for you. Do you have a place to be?
No, sir, I don't at the moment.
All right. I'm also in the alternative going to set some bonds if pretrial release won't take him. So it's going to be in the alternative. Bond in count 1 will be set in the amount of $1,000. Counts 2 and 3 in the amount of $500 each, or pretrial release if he qualifies.
Yes, Judge.
And if I didn't previously announce it, I'll appoint the Office of the Public Defender.
Thank you.
Thanks. Eric Neal.
Your Honor, They said that they cannot, the jail staff told me they cannot bring him over due to COVID restrictions right now.
Okay.
I'm not 100% clear what that means.
I'm not either, and we have a witness present on Mr. Neal's case.
Because I don't think he's going to be reset for tomorrow, I can waive his appearance
All right.
and act on his behalf if that's okay with the court.
Based on Mr. Neal's incarceration, the court's going to appoint the Office of the Public Defender in 2020 MM 2931. I'll accept the waiver of his appearance for purposes of the initial appearance. I have read the charging affidavit, and I do find probable cause for his initial arrest. We do have a witness present, who I assume is Ms. Neal. We're going to place you under oath.
Do you solemnly swear or affirm to testify the truth and nothing but the truth to help you God?
Yes, I do.
Thank you, Ms. Neal. I have found probable cause for Mr. Neal's initial arrest. I will be considering conditions of bond. Do you wish to be heard as to that consideration?
Yes.
All right, thank you. You've been sworn, so just let me know.
Okay, we were just having a family vacation with alcohol involved. It was just a heated argument. And security came up because we were at a family hotel, and he was like trying to quiet me down like this, and they witnessed it, and that's how he was taken.
All right, thank you. Where's home?
Home is Spring Hill, Florida.
Florida?
Mm-hmm.
All right, thank you. If the court were to consider allowing contact between you two, I'd be considering something called no hostile contact. You've heard me explain that a couple times this afternoon. Do you have any fear of having contact with Mr. Neal?
No, he's a good father, a great man. We've never had an issue like this.
Tell me about the children. How old?
She's 4.
4? All right. Any concerns of violence between Mr. Neal and the child?
No.
All right. Thank you. If the court were to allow no hostile contact between you two, would you wish for him to return to the family home?
Yes, please.
And do you have means of communication, cell phone or telephone at home?
Yes.
That you could call local law enforcement?
Yes.
Right, thank you. Have you got everything out of the hotel that you were staying at?
Yes.
All right, thank you. Any follow-up questions, Mr. Moffett? Mr. King, any follow-up questions?
Yes, Your Honor. Ma'am, you don't have any fear of Mr. Neal?
No, not at all.
You wish to have contact with him?
Yes, I do.
You wish him to be able to live with you?
Yes, I do.
He's never done anything violent before?
Never, no.
If he was to ever get violent, would you take necessary steps such as calling the police?
Yes, I would.
On that date, did he actually or intentionally touch you?
No, it was never a violent encounter. It was just loud screaming.
Did he intentionally cause any bodily harm to you?
No.
Do you wish to press charges against him?
No, I do not.
Okay, that's all, Your Honor. Thank you.
Any follow-up questions, Mr. Moffett?
No, Your Honor.
Thanks. All right, the court is going to accept Mr. Neal's waiver of appearance based on him being unable to attend initial appearance due to no fault of his own. Court is going to set a bond in this case. It will be $500 with pretrial release conditions. Mr. Neal is not to consume or be under the influence of any alcohol as a condition of his pretrial release. He may cohabitate and return to the family home with the alleged victim in this case. He may have no hostile contact with Ms. Neal. Ms. Neal, you're in the best possible position to gauge the danger to your family and your children, and the court will allow no hostile contact with Mr. Neal. We're going to generate some paperwork. He should be bondable here pretty soon.
Okay, thank you so much.
Thank you. Counsel, you've been patiently waiting.
Judge, I have a plea on an Orange County case that I think Judge Gibson spoke to you about.
Yeah. Yeah, I've only got a couple more of the initial appearances, then I'll take you.
Okay.
Thought you
Your
might.
Honor, just one more left.
All right, thank you. Yes, sir.
Vale Martinez is in detox, so he needs to be reset for tomorrow.
All right, thank you. We'll reset Mr. Valle Martinez's cases for tomorrow.
And last is Miss Tammy Walker.
Thanks, Ms. Walker. Ms. Walker, you are here based on an allegation of battery on a person 65 years of age or older, misuse of the 911 system, and resisting an officer without violence. I have read the charging affidavit. I find probable cause for battery on a person 65 years of age or older and resisting an officer without violence. Court's not going to find probable cause as to the misuse of 911 system. I'm going to ROR you on that particular count. As to the first count, your bond is going to be set in the amount of $1,500 with the special condition that you have no contact with the alleged victim in this case, which I think is Dad, John Walker. You're not to return to the 3954 Rambler Avenue address until this is sorted out. Do you have any personal belongings there?
Yes, I actually run an animal rescue from that residence. I have about 40 livestock there, and I own everything in the home.
Right. Got any friends or neighbors that can assist you with the livestock?
I do not.
Who else lives in the home?
My biological father, my biological mother, and my sister.
All right. You'll have to petition your trial judge to allow you to return more than the one time to get some personal belongings with law enforcement. I will allow you to return one time with law enforcement to get some personal belongings while that's pending. As to the third count, resisting an officer without violence, I'm going to set bond in the amount of $250. I will appoint the Office of the Public Defender to represent your interests in this case.
Thank you.
All right, thanks.
Your Honor, that's everybody over here. Yes, that's all for us over here, Your Honor.
Thanks. All right, that will conclude initial appearances. Thanks for your assistance, Mr. King, Mr. Moffitt, Mr.
Thank you.
Kendo. All right, let's do, I think we should have someone here for a plea. And that would be, is that Mr. Martin?
Yes, Justin Andrew Martin.
Thank you.
We gotta actually go get Mr. Martin from the pod.
Sorry, I can't hear you. Corrections?
We have to go get him from the pod.
Got it. Okay.
Give me about like 5 minutes, we'll get him.
All right, thank you. Sauer Haber, thanks for your patience. I was attempting to streamline the process for you at Judge Gibson's request, and I think I've probably delayed you.
It's okay, I have 2 o'clock next Thursday.
All right. Do you need these ones?
Yeah.
These for me? Okay. Sorry. I'm giving them back to you piecemeal now.
Do you need copies of them? Okay.
Have a good day, Judge. See you tomorrow.
See you, Officer Kenny.
These are the original. Bye, Ray.
Wow. Okay.
Yeah, that's what we got for me.
Gotcha. Sorry about that. Up and out of order. I think they were in alphabetical order just today. So.
Thank you.
Oops, I got one more for you. Mr. Carrier. Sorry about that. Mr. Moffitt, are you pinch hitting for the state on this one?
I believe so.
Thanks. How things?
What's that?
I said, how things?
Not bad, can't complain. I mean, except for this.
Yeah. It's been a weird year.
Yeah. Like, I was in shock when they, like, closed all the restaurants and bars.
California's closing back down again.
I know. And we have almost 10,000 cases a day. But I already had it once, so I feel. I was going to take the attitude I can't get it again, but the more I thought about it was, you know what? You know, if the experts don't know, how could I, right?
Yeah, I'm figuring out, and the experts don't. I'm not quite sure how this works.
Yeah, no, you're right about that. And I really wasn't that sick. I mean,
either.
Body aches and a headache, like a flu when you're a kid. You know what I'm saying? I didn't have any cough. I didn't have nothing.
Yep. I had an easy go of it.
Oh, you had it too? Yeah. Took longer to get my energy back. Like, I'll make an excuse at like 2 every afternoon.
Yeah.
Release Delta Alpha 2.
Good afternoon, Mr. Martin.
Yes, sir.
All right, thanks. Thanks, Corrections, for grabbing Mr. Martin for us. All right, we are here on Mr. Martin's case 2020 CT 2685. This is an Orange County County case at the request of your trial judge, Judge Gibson. I am attempting to effectuate the plea this afternoon. We are all dual sworn, so I have authority to operate in county court. This will be a county court procedure. Any objections to the court moving forward as a county judge, either side?
No, Your Honor.
All right, thank you. Without objection from the parties, then the court will put its county court hat on and conduct our plea as a county court cross-sworn judge. With that being placed on the record, Judge Gibson has filed or sent some correspondence to this court indicating that she accepts the admission and the proposed terms of the sanctions for the admission in Mr. Martin's violation of probation case. Those anticipated sanctions would be a 40-day jail sentence with credit for the time he has already served, which is 35 days.
Okay, yeah. I had 36, but that's close enough.
All right, thanks. Sorry, do you have a submission form? Yeah, come on up. Thanks. Mr. Martin, your attorney has just handed me a document. It looks like it's sworn, and it is the admission of violation of probation. We're going to place you under oath.
Please raise your right hand. Please raise your right hand.
Okay, go ahead.
Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
True, yes.
All right, the admission form that I have is got a signature where it says defendant. Looks like Justin Martin is the signature. I've got my finger by it. I know you're a long way away. Did you have an opportunity to sign the admission form?
Absolutely, yes.
What the admission form tells me is that you've actually had enough time to read it. You've gone over it with Mr. Sauer. He's answered all your questions. You understand all the rights and obligations, correct?
Yes, sir.
It also tells me that you wish to admit that you have violated your probation in 2020 CT 2685 for the reasons alleged by your probation officer. Is that correct?
True. Yes.
You understand you have a right to have a hearing contesting the finding that you had violated probation. At that hearing, the state of Florida would have to prove to the court, that would have been to Judge Gibson, that you had violated your probation in a material and a willful way. At that hearing, your attorney would have been with you, would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have participated in that hearing, had it recorded, and appealed any error that occurred in that process. You understand you've given up all your hearing rights because if the court accepts this admission, I'm going to go along with this agreement. We're not going to be having a hearing in this matter. Do you understand that?
Yes, sir.
Is anyone forcing you or pressuring you into making this decision?
No, sir.
Has anyone made you any promises other than what is written on your admission form and what we've talked about here in open court?
No, sir.
Under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No, sir.
Do you understand if you're not a United States citizen, entry this admission would cause you to be deported?
Yes, sir.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry this admission could cause you to be involuntarily civilly committed. Do you understand that's the state of the law?
Yeah.
Sorry, we're stipulating to a factual basis for purposes of the admission.
For purposes of the admission, we'll admit that he was arrested on November 2nd for a simple battery. And then there's a special condition 9 that he consumed alcohol. We'll admit that. There's a special condition that he failed to complete a victim's awareness program. It's not really ripe yet, but for the purpose of the plea, we'll admit that too.
All right, the court's going to accept the admission, find that I do have a factual basis with which the court can accept the admission, find that Mr. Martin appears to be alert, intelligent. He's had an opportunity to think about the decision and discuss it with his attorney. You satisfied with your attorney's help?
Yes.
Seems like he's been working awful hard for you and effectuated this unusual hearing in front of me, apparently not to delay you. Is this a revoke and terminate?
Yes.
Court's going to revoke and terminate Mr. Martin's probation. He's going to be sentenced to 40 days in jail. Give credit for the 35 days in the jail that he has already served between Orange and Osceola counties. Were they all here in Osceola County then?
I think 2 were underlying and their balance were here.
So he'll get credit for 35 days. Any costs that he owed need to be paid to the clerk of the court in Orange County. I guess he was on probation over there. And those costs need to be paid within a period of 12 months. No court costs? Okay. All right, sounds like you were up to date with your court costs. Anything further from the state?
No.
Anything further, defense?
My only question is, there's some procedure in place for this to make it to Orange County dockets or wherever, so normally this would be a time-served offer. I just don't know when he's going to be released from Osceola, I guess.
Yeah, I can't order the jail to give him good and gain time.
No, I know,
but,
I know. That's
it's
why
my understanding that he either should be completed with his sentence or very close to completed with his sentence. And should he not be released for any reason, you can bring this back before the court in an emergency fashion. Mr. Martin, you're going to have 30 days from today's date to appeal the judgment and sentence to the court. If you wish to do so, you must do it in writing. Can't afford an attorney, won't. I said you'll have 30 days from today's date to appeal the judgment and sentence. Should you wish to do so, you must do it in writing. And if you can't afford an attorney, one would be appointed for you.
I understand.
All right. Thanks.
All right. Thank you, Your Honor.
Good luck to you, Mr. Martin. Thanks. Good catching up with you. Thanks. Thanks, Mr. Monmouth. We'll be in recess.
Thank you. Thank you.
morning, everybody. My name is Judge Wish. It is December 7th, 2020, and we are in BRC 1. Can I have the parties announce themselves for the record, please?
Good morning, Edith Bush for the Office of the State Attorney.
James Thompson on behalf of the Office of the Public Defender.
All right, and anybody in the gallery out there, if you're going to testify today as a witness, I'm going to ask that you please stand and raise your right hand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth? Okay, I'm assuming you're all talking. I can't see your mouths, so yes, it's fine. You can keep the mask on. And I'll let you know when you come into the booth to testify, it's very difficult to hear because of the microphone, and then we're all wearing masks. But I'd ask that you keep the mask on and just get as close to the microphone as possible so that we can understand you, so we don't have to keep repeating ourselves as well as you, okay? All right. Good morning, sir. Tell me your name, please.
Kazir Step.
Okay, Mr. Stepp, the public defender was appointed previously for you in 2020 MM 930AW. This is your arraignment for disorderly intoxication. Looks like... Are you on probation, Mr. Stepp?
No.
Okay. Is this your only case?
No, Your Honor.
He has other cases?
Yes.
Okay, so this is a misdemeanor of the second degree alleged to have occurred on or about the 4th day of November 2020. Is this related to a felony?
No,
Oh, no? Okay. Is there an offer? I have 29 days.
Yes, there's an offer. The state counted 34 days, but I'll go with the courts. It's
have
a
34.
credit time served offer.
Okay, I'm just going by what the clerk has on here. So they're saying 11/4 to today. So
My calculator
have
said
34.
34 days.
11/4 to today is, I don't know how many days.
It's
34. Okay.
And it's an adjudication of guilt, 34 days, Orange County Jail, 34 days credit time served. No contact with victims or witnesses. No return to the scene, the Quadro Supermarket at 23 West Silver Star Road in Ocoee. Abide by any trespass warnings. Cost of investigation to the Ocoee Police Department in the amount of $178.64 and court costs.
All right, Mr. Stepp, did you understand that offer?
Yes, ma'am.
Do you want to accept the offer?
Yes.
Okay. Did you read the plea form?
Not without reading glasses.
Okay, all right. So, Mr. Thompson, your office was appointed. Let me have you go over the plea form with Mr. Stepp, okay?
All right. So,
I just sign here.
yeah, step again. Yeah, he indicated that he understands it and he's read it before.
Okay.
He's read it.
He didn't tell me that he'd read it before. He just said, well, he didn't read it without his reading glasses, so. Okay, so Mr. Stepp, have you read that plea form before?
Yes.
When was the last time that you read it?
Just recently.
Okay, and did you understand everything that was on the plea form when you read it?
Yes.
Did you understand all the constitutional rights you're giving up by entering the plea?
Yep.
Are you on, and I asked you, but I'm gonna ask you again, are you on probation?
No.
Okay, and do you understand if you're not a US citizen, the plea will subject you to deportation?
Yes.
Okay. I do find that there's a factual basis based on the affidavit in the court file to accept your plea. I'll adjudicate you guilty, sentence you to 34 days with credit for 34 days time served. No contact with victims or witnesses. No return back to the Quadro Supermarket at 23 Silver Star Road. Abide by any trespass warning there. There's a cost of investigation to the Ocoee Police Department in the amount of $178.64. I'll order you pay your costs and fees by December 7th, 2021. That gives you a year. If you'd like to appeal the judgment, sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one would be appointed for you, sir. Good luck. Interpreter.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good morning, Ms. Romero. This is Judge Wish, and we are in BRC 1. The defendant is at the podium and has the headphones on.
Okay, one moment, Your Honor.
Okay, just
Your
let me
Honor,
know
allow
when
me
you
to
think
connect.
back.
Thank you.
Sí, puedo escucharlo.
Yes, he can hear the interpreter, Your Honor.
Okay, good morning, sir. Tell me your name.
Alberto Zaya Rodríguez. Rodríguez.
Alberto Sayas Rodriguez.
All right, sir, you're here in case number 2020 CT 7550AO. You were arrested for no motor vehicle registration. There is probable cause. Ms. Bush, did you have an offer on the case?
Yes, Your Honor. I'm trying to see if I can possibly include the out on release cases as well. So if I may have just one moment. Because neither of them are in our system, so.
¿Le puedo decir algo?
May I say something?
Mr. Zayas Rodriguez, I would not talk about the facts of the case. Do you want to try to resolve your cases today? You have 2 out on release cases, one of which is attaching a tag to a
Dígame.
plate unassigned, or to a vehicle unassigned, excuse me, and then no motor vehicle registration, which I believe is the same vehicle. So you've got 2 no motor vehicle registrations and attaching a tag. The state attorney is going to see if she's going to do a global offer for all 3 cases. So you don't need to go back to court. Are you interested in that?
Sí.
Okay, so
Okay, gracias.
just hang
Sí.
on a sec,
Yes.
okay?
And, Your Honor, on today's case, 2020 CT 75500, the state's offer is an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, and a $250 fine. And don't drive a vehicle that is not properly registered. And court costs. On the 2 out on release cases, 2020 CT 7248 and 7249, those are also adjudications of guilt, credit time served, and court costs.
Okay, do we know what the credit for time served is? Is it 1? 2 days. 2 days? Okay. All right. So, Mr. Zayas Rodriguez, the state's offer today on the new case is an adjudication of guilt, 2 days credit for time served, meaning you would get out today, and a $250 fine as well as court costs. For the other 2 cases that I mentioned, you would also be adjudicated guilty. You would have 2 days credit for time served in those cases, and I would also have to impose court costs. So I would give you a year to pay off your court costs and the fine and fees. Did you want to do that today, and you will not have to go back to court, which I think you have in 3 days for the other cases? Yes? See?
Sí, thank you.
Yes, thank you.
Okay. Did you read the plea form?
No.
Okay, I'm going to need
No.
you to read the plea form for me. Let me know when you're done.
Okay.
Okay.
So those arraignments can be canceled on the other cases. Thanks.
Okay.
Okay, you finished? Did you understand everything on the plea form, sir?
Sí, es correcto.
Yes, that is correct.
Okay. And do you understand all those constitutional rights that you're giving up by entering the pleas?
Okay.
Okay.
My question called for a yes or no answer. Did you understand the constitutional rights you're giving up by entering the plea?
Sí, es correcto.
Yes, that is correct.
And are you on probation anywhere, sir?
No, yo nunca he tenido problemas con la corte.
I never had any problems with the courts.
Okay, so you're not on probation is what you're saying?
No,
All right, do you understand that if
no,
you're
yo
not
nunca he tenido problemas. Yo nunca casi.
I never had any problems.
Okay. Do you understand if you're not a U.S. citizen, the pleas will subject you to deportation?
I'm Puerto Rican.
Puerto Rican.
I'm puertorriqueño.
Right. I have to advise everybody that if you are not a U.S. citizen, the plea will subject you to deportation. So I need to make sure you understand that, whether you are a U.S. citizen or not. You're nodding your head, but I need an answer out loud.
Yeah, I understand.
Yes, I understand.
Okay. Please speak in Spanish if you're going to use the interpreter. I do find that there's factual basis to accept your plea in all three cases based on the affidavits in the court file. I'll adjudicate you guilty in 2020 CT 7550AO. Sentence you to 2 days with credit for 2 days time served. There's also a $250 fine. You may not drive without properly registering your motor vehicle. And I'll impose court costs as well. In 2020 CT 7249 and 7248, I'll adjudicate you guilty on both charges. Sentence you to 2 days with credit for 2 days time served. Those counts will run concurrent as well as concurrent with the other case. I'll also impose court costs. On both on all three of your cases, your court costs and fees will be due by December 7th, 2021. If you'd like to appeal the judgment and sentences of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you, sir. Thank you. Good luck. Okay, and then we don't need JNSs for those cases.
Gracias.
Thank you.
Hey, algo.
Good morning, sir. Please tell me your name.
Billy Joe Quintana. Billy Joe Quintana.
Virgilio Quintana.
Sí.
All right, sir, you're here in 2020 CF 14497 AO. You're arrested for a violation of a no contact order. I do find that there is probable cause. I will appoint the public defender's office to represent you in your case. You are not to have any contact directly or indirectly with the victim in the case. You saw Judge Yansevich the other day, I believe yesterday or the day before. She ordered that you were to have no contact.
Sí, ayer.
So I am ordering it again. That means no phone calls, no emails, no text messaging, no communicating with the victim in any way, shape, or form. Do you understand? I'll have you sign the no contact order, please.
Una pregunta. Ayer yo fui 30 minutos. Yo no sabía que yo necesitaba mi ropa para ir a trabajar hoy. 30 minutos después apareció la policía y yo no sabía.
Yesterday, I went for 30 minutes to get my.
That's what I do too.
Okay.
Mr. Thompson, you may want to let him know that he should not talk about the facts of the case. Okay.
Okay.
All right, sir. So again, no contact directly or indirectly with the victim. Did we have a no contact order form for him? We'll have him sign that form. You're not to return back to where the offense is alleged to have occurred. You're not to possess any weapons or firearms or any ammunition. I am revoking the bond in that case, setting the bond at none. Do we know if the public defender was previously appointed?
No me puede dar una fianza para trabajar porque en verdad necesito el dinero. Ya son las Christmas and I.
Sir, I would not talk about the facts of the case. You have the public defender's office. They will be able to file any appropriate motions to set bond for you. On this new case, I'm setting your bond at $2,500. Thank you, sir.
¿En cuál caso?
Which case? Is he without bond?
The public defender is appointed in both cases for you. They were previously appointed as well by Judge Yansevich on the case that I revoked. So you have the public defender. They will have to file a motion to set bond for you. Mr. Thompson, did you want to explain anything to him?
Really quick.
You have the headphones on, so that's what I figured.
No me pueden dar una fianza hoy porque.
We're going to try to file a motion before you get the ball and put it downtown. I appreciate it. Right. Right now, you're not entitled to the bond.
¿En cuánto tiempo?
I don't know. I'm hoping.
Yo no estaba filmando ese de ahí.
He's asking if he had to sign that there.
I can't hear you, ma'am.
He was asking if he had to sign that there.
Yes, it's a
I
no
believe that's-
contact order. You've already signed one. I'm having you sign another one.
Una pregunta.
Is that one in
Ayer,
Spanish?
ayer, ustedes me
Sir, I
metieron.
would not talk about the facts of the case. If you have a
No,
question and you
okay,
want to talk about
no
anything,
es del
then you'll
caso.
need to. Please stop talking. Mr. Thompson, I don't want him to continue to talk, so if he wants to, okay, if he had a question, I would let you get on the headphone, but he had plenty of opportunity to
Yeah, I
discuss
told-
anything with you.
I told everything he
Okay.
knew.
All right, does he need the headphones?
No, ma'am.
We're done with Spanish? Okay, all right. Thank you, Madam Interpreter.
You're welcome, Your Honor.
All right, good morning, sir. Tell me your name.
Luis Fernandez, Your Honor.
Mr. Fernandez, you're here in 2020 CF 14500AO. You're arrested for possession of cocaine, battery, domestic violence, and resisting an officer without violence. There is probable cause. I don't have a form for the public defender. Did you fill one out, Mr.
No, ma'am. I'm
Fernandez?
doing private counsel.
Okay. I'm gonna have you sign the no contact order, which I think you just did. Did you
Yes,
read
ma'am.
and understand everything on it?
I did. I just have a question about it.
Okay, what's your question?
The no contact orders for my girlfriend, and she was the one saying that she didn't want to press charges. So how do I get the no contact order removed, ma'am?
Okay, so your attorney, well,
Yes, ma'am.
and I don't know who your attorney is
It's
going
Mr.
to be
Pearson,
because I'm
but yes,
not
ma'am.
appointing the public defender. They're going to have to file a motion to modify that no contact order with
Mhm.
the judge in Division 12, okay?
Yes, ma'am.
Or you can write the judge, but usually you'll get maybe a hearing quickly if you have an attorney file a motion versus sending a letter,
Yes,
okay?
ma'am.
Do you understand?
Yes, ma'am.
Okay. You're to maintain a separate residence. You don't live together, correct?
No, ma'am.
Okay. You're not to possess any weapons or firearms or any ammunition, no drugs or alcohol without a valid prescription.
Yes, ma'am.
Did he end up qualifying for pretrial release?
He was never interviewed, so if you can do a bond or PTR.
Okay, so I'm gonna have them, if you'd like to bond, that's fine. I'm gonna stay the bond at the $1,000. Count 2 will be 500, count 3 will be 100, or pretrial release. If they're able to qualify you, they'll probably come and ask you some questions, but if you'd like to bond out first, then you can do that.
Yes, ma'am.
Okay? Thank you, sir.
Thank you, Your Honor.
Good morning, Judge.
Good morning. Tell me your name.
Bruce Lewis.
All right, Mr. Lewis, you're here in 2020 CF 14506AO. You were arrested for aggravated child abuse and 3 counts of battery with 1 prior battery domestic violence. I don't find that there's probable cause for the aggravated child abuse. I find probable cause for the lesser included offense of child abuse. 827.03 subsection 2 subsection D. I don't find anything in here to indicate that there was an aggravated child abuse. There would have to be injury to the child, which there was none.
Yes, Your Honor, the state's not making.
Additionally, there's nothing in here about the 1 prior battery conviction.
It actually got
As
dropped,
I
ma'am?
looked, hold on,
Oh,
Mr.
sorry.
Lewis. As I looked up in the affidavit, there's nothing in there, as well as on his face sheet, there's nothing on there as to any prior battery conviction. He's been arrested previously, but I don't see any prior domestic violence or any prior battery conviction, I should say.
And, Your Honor, the state has already made a request of Orange County to obtain that probable cause. The state would ask for 24 hours.
Okay, I'm still gonna give him a bond today, Ms. Bush, but it will be reset for probable cause tomorrow. Based on my review of the face sheet, I don't believe that he has the prior. So, what I'm gonna do is, so I did find the lesser included offense of child abuse for count 1, which again is 827.03 subsection 2 subsection D. And the state will get additional probable cause time for counts 2, 3, and 4, although I am going to give you a bond today,
Yes,
okay?
ma'am.
So I'm
Thank you.
going to set the bond on count 1 at $2,500. Counts 2, 3, and 4 will be set at $500 each. You're not to have any contact directly or indirectly with any victim or witness in the case. Okay, you're to maintain a separate residence. You may return one time with law enforcement to get your personal belongings, but you must be with law enforcement, Mr. Lewis. Do you understand?
Yes, ma'am.
Okay. No weapons, firearms, or ammunition, no drugs or alcohol without a valid prescription, and comply with any Department of Children and Families investigation that there may be pending. Okay, so if you're
Yes, ma'am.
unable to bond out, then it will be reset for tomorrow for the probable cause for counts 2, 3, and 4. Okay?
Thank you so much, Your Honor.
All right. Good morning. Tell me your name.
Name is Gregory Mills.
All right, Mr. Mills, you're here in 2020 CF 14502AO. You're arrested for aggravated battery with a deadly weapon, domestic violence. There is probable cause. I'll appoint the public defender. You're not to have any contact directly or indirectly with any victim or witness. I'll have you sign the no contact order form. Do you understand everything on it, sir?
Yes, ma'am.
Okay, you're to maintain a separate residence. You may return one time with law enforcement to get your personal belongings.
Yes, ma'am.
Should you need to do so, no weapons or firearms or any ammunition. Your bond is set at $10,000. Thank you, sir.
At 10.
Good morning. Tell me your name, please.
State your name.
Tell me your name.
Ricardo Nieves.
All right, Mr. Nieves, you're here in 2020 CF 14510AO. You were arrested for false imprisonment, domestic violence, battery with one prior battery, domestic violence, and criminal mischief over $1,000. I find probable cause for count 1 and 3. I do not find probable cause for count 2. The case that they list in the affidavit, that is the prior, allegedly the prior battery conviction, I pulled it up. He pled, and it's also on the face sheet, as a resisting an officer without violence. I guess it came in originally as a battery domestic violence, but it was filed only as a resisting, and it remained in Division 50. So there's no probable cause. I don't see any other prior battery convictions.
Your Honor, the state would ask the court to find just the battery.
So I find probable cause for count 2, the lesser included offense of domestic violence battery, which is 784.03-10. Okay, so now that's out of the way, and I did appoint the public defender. We do have a witness present. Good morning.
Good morning.
Were you sworn in earlier?
Huh?
Were you sworn in earlier?
Yeah.
Did I swear you in? Were you sitting there? No? Okay. Can you raise your right hand? Your right hand. Yes, thank you. Did you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Now, I made an announcement you weren't here, but if it's very difficult to hear, you have to keep your mask on, but you're very tall, so I just need you to crouch down. I know it's uncomfortable, but I can't hear you unless you're speaking directly into the microphone, okay?
Okay.
Can you tell me your name and spell your last name, please?
Evelyn Correa.
Okay, Miss, and can you spell your last name?
It's C-O-R-R-A-E. Correa.
Okay. Miss Correa?
Yes.
Okay. Miss Bush, did you wish to inquire?
Yes, thank you. Good morning, Miss Carrere. What is your relationship with Mr. Nieves?
He's my husband.
Do you all live together?
Yes.
Do you want to have contact with him while this case is pending?
Yeah. Yes.
Are you afraid of him?
No.
How long have you been in a relationship with him?
Almost 2 years.
And over the course of those 2 years, has there ever been any violence in your relationship?
No.
And, Your Honor, if I may have just one moment. Do you believe that alcohol or any kind of controlled substance may have contributed to Mr. Nieves' behavior?
Yeah.
I'm sorry?
Yes.
You do. Who else lives with you in the home?
Just me and him only.
And if something like this were to happen again, would you be comfortable calling law enforcement if you felt that your safety was threatened?
Yes.
And if I may just have one moment, Your Honor, if I may have a moment.
Sure.
And if I could just ask, pretrial
She's the
services?
previous victim in his last 2 arrests,
Oh.
if that's what you're inquiring.
Yes, because that case number comes up to somebody else. That's
It's
the reason.
11954.
11954. All right, thank you. That's where my hesitation was. And you said that there's been no prior violence in the relationship.
No.
And just last month, wasn't he arrested for domestic violence?
Yes.
All right, I have no further questions. Thank you, ma'am.
All right, Mr. Thompson, do you have any questions for Ms. Correa?
No questions, Your Honor.
Okay. Thank you, Ms. Correa, for your testimony. I am ordering no contact. It appears as though Judge McInnes previously ordered non-hostile violent or no hostile violent or contact, but that does not appear to be working at this time. So I am going to order no contact. So, Mr. Nieves, I'm going to have you sign the no contact order form. That's no contact directly or indirectly, no phone calls, no emails, no text messaging, no communication through a third party. Do you understand?
Yes, ma'am.
Is that a yes?
Yes, ma'am.
Okay. You're also not to have any contact with any witness in the case. You're to maintain a separate residence. You may return to the residence one time to get your personal belongings, but you must be with law enforcement to get them. You're not to possess or consume any drugs or alcohol without a valid prescription, and no weapons or firearms or any ammunition. Your bond on this case on count 1 will be set at $5,000. Count 2 will be set at $1,000. Count 3 will be set at $150,000. I am revoking the pretrial release and setting that bond at none. I believe you have the public defender in that case. They're going to have to file a motion to set bond for you in that matter. Thank you, Ms. Carrera. He has the PD in that case, right? Okay.
O'Neill, is mental health.
Mr. O'Neill? Okay. All right. So I'm going to appoint the public defender for Mr. O'Neill. Mr. Thompson, do you want to waive his appearance?
Yes, Your Honor.
Okay, that's 2020 CF 13717. And that was a warrant for aggravated stalking domestic violence. Probable cause was previously found. He's not to have any contact directly or indirectly with the victim or any of the victim's family members. He's not to return back to the scene, nor is he to go to the victim's residence or any of the victim's family members' residences. No weapons, firearms, or ammunition, no drugs or alcohol without a valid prescription. He's to surrender any weapons or firearms or ammunition within 6 hours of release from the jail. The bond is set at $15,000. You got the family and all that stuff. So no contact with the victim's family, and then no return to the victim's residence or the victim's, or the scene, or the victim's family residences. Okay, perfect. Good morning, tell me your name.
Good morning. My name is Mervyn Thompson.
Okay, Mr. Thompson, you're here in 2020 CF 14100. You were arrested pursuant to a warrant. Probable cause was found for domestic violence battery and false imprisonment. And I will appoint the public defender to represent you in your case. You're not to have any contact directly or indirectly with the victim. I'll have you sign the no contact order. Do you understand everything on it?
Yeah, I do.
You're to maintain a separate residence. You're not to return back to where the offense is alleged to have occurred. You're not to possess weapons, firearms, or any ammunition. You're to comply with the injunction in 2020 DR 012524-0. Looks like you have a final hearing tomorrow, okay?
Okay.
And you do qualify for pretrial release. I'm going to place you in pretrial release. Do not violate the pretrial release or my court orders, okay?
Okay.
All right, and I'm striking, no, all conditions on the warrant will remain, okay? All right, thank you, sir. Good luck.
Thank you.
Good morning, tell me your name.
Raymond Gerard Williams Sr.
All right, Mr. Williams, you're here in 2020 CF 14490AO. You're arrested for aggravated battery causing great bodily harm, domestic violence. There is probable cause. I'll appoint the public defender. Good morning.
Good morning.
Were you sworn in?
Yes, ma'am.
Okay, and I'll, again, just need you to get as close as possible to the microphone for me. Can you tell me your name and spell your last name?
Alicia Lynette Gilbert.
I couldn't hear you.
Alicia Lynette Gilbert.
Miss Gilbert?
Yes, ma'am.
Okay. And Miss Bush, did you wish to inquire? You may need to speak up a little louder, Miss Gilbert. It's just hard with the microphone and the mask and everything.
Okay.
Good morning, Ms. Gilbert. What is your relationship with Mr. Williams?
I have 4 kids from him.
And are you all currently in a romantic relationship?
No, ma'am.
Do you live with him?
No, ma'am.
Are you afraid of him?
No, ma'am.
Do you want to have contact with him while this case is pending?
Yes,
beyond?
Yes, ma'am.
Okay. So you want to have full contact with him and you have no concern about your safety or your children's safety?
No, ma'am.
How long have you been in a relationship with him?
20 years.
How many?
20.
And over the course of that time, has there been prior violence in your relationship?
No, ma'am.
Are you aware that he has been convicted of violent crimes?
Yes, ma'am.
And that doesn't give you any concerns?
No, ma'am.
And do you have any concerns about your children's safety around Mr. Williams?
No, ma'am.
Do you have any concerns about your children witnessing their father and mother engaged in any kind of physical altercation?
No, ma'am.
And if something like this were to happen again, and you felt that your safety was in jeopardy or your children's safety was in jeopardy, would you call law enforcement?
Yes, ma'am, but it won't happen no more.
All right. Thank you very much, ma'am.
All right, Mr. Thompson.
No questions, Your Honor.
Okay, Miss Gilbert, you indicated that there was not prior violence in the relationship, but it's alleged on the base sheet that I have that with his prior history that you were a prior victim in 2 other cases that were declined to be prosecuted. Is that correct?
I don't know nothing about that.
So there was one in 2006 and one in 2002?
I don't remember.
Okay, all right. All right, I am ordering no contact today. That's something that his attorneys will file a motion about if you want to have contact or he wants to have contact with you. So, Mr. Williams, I'm going to have you sign the no contact order form. Do you understand everything on the form?
Yes.
Okay. You're also to maintain a separate residence, no return to where the offense is alleged to have occurred. You're not to possess weapons or firearms or any ammunition. And I'm also adding no contact with any witnesses in the case.
Excuse me.
Your bond is set at $7,500. All right, thank you, ma'am.
Excuse me, what if you want to drop the charges?
I'm sorry?
What if I want to just drop the charges?
I can't hear her.
What if she wants to drop the charges?
Then you'll have to speak with the state attorney's office. You'll have to call them and you'll have to speak with somebody who is assigned to the case.
Okay, thank you.
Okay?
Thank you.
Good morning. Tell me your name.
Danielle.
Tell me your last name.
Danielle Bodkin.
All right, Ms. Bodkin, you're here in 2020 MM 8661AO. You're arrested for dating violence battery. There is probable cause. I'll appoint the public defender to represent you in your case. Good morning, sir.
Good morning.
Were you sworn in?
Yes, I was.
Okay, and then it's very hard to hear, as I've stated. So if you could just speak as loudly as possible. I know it may be weird.
Yeah, I was sworn in.
Perfect. Can you tell me your name and spell your last name for me, please?
Joshua Brown, and that's Brown.
Okay. Ms. Bush, did you wish to inquire?
Thank you, Your Honor. Good morning, Mr. Brown.
Good morning.
What is your relationship with Miss Bodkin?
That's my girlfriend.
Do you all live together?
Yes, we do.
Are you afraid of her?
No.
Do you want to have contact with her while this case is pending?
Yes, please.
How long have you been in a relationship with her?
2.5 years.
And over the course of the 2.5 years, has there ever been any form of violence?
No, none.
Do you believe that alcohol or any kind of controlled substance might have contributed to her behavior?
Yes.
And should something like this event occur again and you felt that your safety was in jeopardy, would you be comfortable calling law enforcement?
Yes.
I have no further questions. Thank you, sir.
Mr. Thompson, any questions?
No questions, Your Honor.
Okay. All right. Thank you, Mr. Brown. I am going to allow you to have contact, Ms. Bodkin. It's non-hostile, non-violent contact. So that's no pushing, shoving, biting, scratching, getting in his face, saying mean things. If you get upset, walk away. All right? You got it?
Yes.
Yes. Okay. You're not to return back to the Marriott Grand Vista Resort at 5925 Avenida Vista, well, that will be the resort. Do you have anything at the resort still?
Yes, she does.
Yes.
Yes. Are you able to get those things?
I can pack up all of our belongings. Does that mean she can't come and pack up her stuff with me?
Sorry?
Does that mean she cannot come and pack up her belongings? Because we have a flight
No,
today.
she can't go back there, but you can go back there and you can get her things.
Okay.
Okay? No weapons or firearms or any ammunition, no drugs or alcohol without a valid prescription. I am going to place you on pretrial release. You'll be able to go back to, is it Philadelphia?
Yes.
Okay, so you'll be able to go back to Philadelphia. I have no problem with you traveling to Philadelphia. You just need to come back if there are any court dates. Okay? Don't miss any court dates if there are any upcoming court dates. All right?
Okay.
All right, good luck.
Thank you.
Good morning. Tell me your name.
Margarita Goffin.
Ms. Goffin, you're here in 2020 MM 292AE. You were arrested for battery, domestic violence. There is probable cause. And I don't have a form. I do have a form for the public defender. I'll appoint them to represent you in your case. You're not to have any contact directly or indirectly with any victim. I'll have you sign the no contact order. Do you understand everything on the order, ma'am?
Yes, ma'am.
All right. You're to maintain a separate residence. You may return one time with law enforcement to get your things. No drugs or alcohol without a valid prescription. You're to take all and any medications as prescribed by your doctor. Do you understand?
Yes, ma'am.
Okay. You're not to possess any weapons or firearms or any ammunition. I'm going to place you on pretrial release.
Okay,
Thank you. Good morning. Tell me your name.
Good morning, Stephen Hughes.
Mr. Hughes, you're here in 2020 MM 594AA. You're arrested for domestic violence battery. I do find that there is probable cause. I'll appoint the public defender. Good morning.
Good morning.
Were you sworn in earlier?
Yes, ma'am.
Okay. Can you state your name and spell your last name for me, please?
Ashley Nelson, Nelson.
All right. Thank you, Ms. Nelson. Ms. Bush, did you wish to inquire?
Thank you, Your Honor. Good morning, Ms. Nelson.
Good morning.
What is your relationship with Mr. Hughes?
He's my husband.
And how long have you been in a relationship?
8 years.
And over the course of those 8 years, has there been prior violence?
Yes, ma'am.
Are you afraid of your husband?
Yes, ma'am.
Do you want to have contact with him while this case is pending?
I do. He lost his mother, and all of her belongings are at my property where I live with my mother now. I would like to have temporary communication to get his belongings to him, and then no further contact.
Outside of that, the ability for him to pack up his belongings, which the court could order as long as he has law enforcement with him. Are you saying that outside of that, you do not want to have contact with him?
No, I need to communicate with him temporarily just to find out what I need to do with his mother's stuff, and make any arrangements for separation, for divorce, whatever I need to do, but very temporary, maybe 5-10 phone calls, and that's it. No further contact at all, nothing. I want him out of my life completely.
And would you be comfortable if that contact was strictly telephonic?
Yes.
Thank you. I have no further questions.
Thank you.
Mr. Thompson, any questions?
No
for
questions, Your Honor.
Ms. Nelson? Okay. So, Ms. Nelson, it's really hard for me to do a temporary contact thing, so I understand that there's some logistics with the property. So I will allow the telephone contact only until this issue with the property is resolved.
Okay, and I would also request that he only contact me directly and not my family.
Okay, so I'll say no hostile contact with the victim, and it's only through telephonic means as it relates to the property of your mother. Okay? Does that make sense?
Yes, ma'am.
Okay. I'm also ordering no contact with the witness, who I believe is your son, and no contact with the victim's family.
Yes.
Okay. So the son, which is a witness, and then any victim family member.
Yes.
So, Mr. Hughes, do you understand that?
Yes.
Okay. So I am going to have you sign the no contact order because it's only modified as to the telephonic and the property. Everything else is no contact with any witnesses and no contact with the victim's family. So I'm going to notate on there and we're going to have court minutes that reflect what kind of contact you can have. But other than that, it's no contact. No phone calls, no emails, no text messaging as it relates to anything other than the property, okay? You're to maintain a separate residence, and I'm going to let him go back one time with law enforcement to get any of his own personal belongings that he may need, but you have to be with law enforcement, Mr. Hughes, okay? No weapons or firearms or any ammunition. Your bond is set at $1,500. All right?
Ma'am, can I also state one thing? My husband has a severe alcohol issue, and that's what creates every violent.
Okay, so I'm going to order no drugs or alcohol without a valid prescription. It's up to him whether he complies with that order, but if he violates it, it's a violation of my order, and it can be a new law violation.
Okay.
So your bond could be revoked if you violate any of those court orders, okay? All right, good luck. Thank you. Can you put property of defendant's deceased mother?
How you doing?
Can I have that no contact order that was just signed by Mr. Hughes? I just want to put a notation on it before I forget. Thank you. Good morning.
Good morning.
Can you tell me your name, please?
Bruce Alexander Padilla Ayala.
All right, Mr. Padilla, you're here in 2020 MM 866-7AO. You were arrested for assault, dating violence, and criminal mischief. And there is probable cause. I will appoint the public defender's office to represent you. Good morning, ma'am.
Good morning.
Were you sworn in?
Yes, ma'am, I was.
Okay, thank you for speaking into the microphone. And can you tell me your name and spell your last name for me, please?
Kayla Lacey, Lacey.
All right, thank you, Miss Lacey. And Miss Bush, did you wish to inquire?
Yes. Good morning, Miss Lacey.
Good morning.
What is your relationship with Mr. Padilla?
He's my boyfriend of 2 years.
And are you afraid of him?
No, ma'am, I'm not.
Do you want to have contact with him while this case is pending?
I would actually like to request contact, yes, ma'am.
And over the course of the 2 years, has there been prior violence in your relationship?
There has been one offense in the past.
And was that just about 2 months ago?
I actually don't remember when it happened, but I had to have been over...
Around October?
This year, correct.
Yes. Correct. And do you believe that alcohol or any kind of controlled substance contributed to his behavior?
Alcohol, for sure.
And do you all reside in the same home?
No. We don't live together right now. No, ma'am.
Okay. If something like this or the prior incident were to happen again, would you be comfortable calling law enforcement if you felt threatened?
Absolutely.
I have no further questions. Thank you, ma'am.
All right, Mr. Thompson.
No questions, Your Honor.
All right, thank you, Miss Lacey. Yes, did you want to say something else?
I just had a question. Even though this was all verbal this time, I wasn't sure if this still would be counted as another assault charge.
Well, it's an assault, which does not need to mean that there was contact, okay?
Okay.
So it's placing you in fear or making doing something verbally or aggressively that places you in fear. It makes you believe that violence is imminent, okay? And based on your testimony and the witness's testimony, I found probable cause for that.
Okay. I just wanted to state that me and him were both intoxicated. So when I wrote my statement, I was very repetitive and I couldn't even remember what happened. It was very verbal. I wasn't scared of my life at all.
Okay, well, you don't need to be scared of your life, okay, for it to be an assault. But
I didn't believe he was going to hit me.
You can talk to the state attorney's office about if they're going to make a charging decision. I don't get to make the charging decisions. I just find probable cause or no probable cause based on what's in the affidavit from law enforcement, okay? So based on my review of the affidavit, as well as the witness's testimony in the affidavit, as well as the prior violence that occurred about 2 months ago, I'm not going to allow contact today. So his attorneys will have to file a motion to modify that if he wants to have contact with you. So, Mr. Padilla, I'm going to have you sign the no contact order form. It's no contact directly or indirectly with any victim or witness. You're to maintain a separate residence. You're not to return to the victim's residence. You're not to possess or consume any drugs or alcohol without a valid prescription. And no weapons, firearms, or any ammunition. I am going to place you on pretrial release. Make sure you don't violate any of those court orders, or it could violate your release, okay? How's your hand?
Can I just say one thing real quick before I tell you that? So I know that me and her had a domestic violence, and the court told me the next time this happens, just go home. And our argument ended before the cops.
Today is not the day to start talking about the facts because you're being recorded.
Okay, sorry.
And the prosecutor's sitting right there.
Sorry.
And they get to make the decisions about the case. So I wouldn't talk about what happened or what didn't happen because that's not going to help you today, okay?
So I have to sit here till how long?
I'm releasing you on pretrial release. So you'll get out today.
Okay.
You can't go to her house. You can't have contact with her or the witness. Do you understand?
Yeah, just one more
question.
question.
No drugs or alcohol.
We don't live together, but we both share phone bills, rent, all these things.
I don't get involved in those day-to-day issues. So if you have questions about those kinds of things, the public defender's office, they're your attorney. So you'll have to ask them. what you need to do. They can file a motion to modify the no contact order, and then you can communicate possibly about those things, but I'm not allowing contact today.
Your Honor.
Okay? Yes?
One last thing. To modify that no contact, I would contact the...
His attorney will have to file a motion with the judge.
Oh, okay.
Okay?
Thank you.
Thank you. All right, tell me your name, please.
Levi Proctor Wells.
Mr. Proctor Wells, you're here in 2020 MM 8654AO. You're arrested for domestic violence battery. I do find that there is probable cause, and I'll appoint the public defender. You're not to have any contact directly or indirectly with any victim. I'll have you sign the no contact order. Do you understand everything on the order, sir?
Yes, ma'am.
Do you all live together?
Yes, ma'am.
Okay. You're to maintain a separate residence. You may return one time with law enforcement to get your things. No weapons, firearms, or any ammunition. Comply with any DCF investigation pending. Your bond is set at $500. All right, thank you, sir. All right, good morning. Tell me your name.
Frank Barber.
Did Mr. Gallen bond? Oh, I'm sorry. I had it. I guess it got messed up here. Okay.
But Mr. Barber bonded already. His bond.
Mr. Barber bonded? All right.
Yes.
I didn't. The paperwork's just on the wrong case here. I'm confused. Okay. So that's Mr. Barber. Here's Mr. Gallen. And he bonded, right?
Mr. Gallen?
Yeah.
He's right.
Oh,
Here.
okay. All right. The paperwork was just on the wrong paper. Okay. Okay. Tell me your name.
Christopher Dale Gallen Jr.
Okay, Mr. Gallen, you're here in 2018 CT 1073AE, 2018 CT 1074AE, 2020 MM 8657AO, and that's a petty theft. There's probable cause. I'll appoint the public defender. Does he already have the public defender in the other cases? No? Okay, I'll appoint them as well. So for the petty theft, no return back to the Walmart at 3101 West Princeton Street, no contact with any victims or witnesses in the case. And abide by any trespass warning if you were provided one. Your bond is going to stay at the $250. I don't have a driving record, so. Oh, there it is. Ms. Bush, did you have offers on the failures to appear? I don't know. He has one well, he has multiple priors, but one in 2013. But I think that's outside of the 5 years, so do you want to try to resolve those today, Mr. Gallen?
Yes, I guess.
Because you have bonds set at $2,500 on each case, so that's that's $5,000 bond. I can't change those or modify those, so.
Okay.
I appointed the public defender. I don't know, Mr. Thompson, if you want to discuss
Yeah, let me, I'm
trying to resolve those.
looking up the cases real quick, Your Honor.
I don't see, he has priors, but he does not have anything within the last 5 years.
And Your Honor, the state's offer, should he want to accept it, would be an adjudication of guilt. Don't drive without a valid driver's license, credit time served, and court costs.
Do we know how much credit per time?
2 days, Your Honor.
Okay, on both those cases, they were the same day? Okay. So he has 2 days credit per time served. I have to advise you, Mr. Gallen, if you wanted to accept the plea offer from the state, it would be an adjudication of guilt, credit for time served on the driving while license suspended and the no motor vehicle registration. I don't know if the state has an offer for the petty theft. I didn't even think about it. But driving while license suspended is an enhanceable offense. So you have priors. The state could at one point file it as a felony if you have 2 prior convictions. If you get 3 within a 5-year period, you will lose your license for 5 years.
Okay.
So this would be strike 1.
Okay.
Okay? The same thing with petty theft, any kind of theft, it's also an enhanceable offense. So same thing, if you get 2 priors, they can charge it as a felony. 1 prior, that goes to a misdemeanor of the 1st degree, okay? So I don't know if Ms. Bush has an offer on the theft. We'll
Your
see.
Honor, the state's offer would be an adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, no return to the Walmart on West Princeton Street, no contact with any victims or witnesses, abide by all trespass warnings, and court costs.
Okay, so it looks like, and I explained to you the enhanceable offense, it's a credit for time served offer on everything today. You could wrap everything up today, you would not have to go back to court, you wouldn't have to post your bond, so you want to discuss that with Mr. Thompson?
Yeah, he says he would like to do it, Your Honor.
Okay, and
Enter
so
a plea of no contest.
everything that I explained to you about the enhanceable offense of driving while license suspended and theft, you understand? Yeah, I need you to speak out loud.
Yes, ma'am.
Okay, did you read the plea form?
Okay.
Yes?
Yes.
Okay, do you understand everything on the plea form?
Yes, ma'am.
Do you understand all the constitutional rights that you're giving up by entering the plea?
Yes, ma'am.
Are you on probation anywhere?
No, ma'am.
Okay. Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
All right, I do find that there is a factual basis based on all of the affidavits in the court files to accept your pleas. On 2018 CT 1073 AE, I'll adjudicate you guilty, sentence you to 2 days with credit for 2 days time served. 2018 CT 1074 AE, I'll adjudicate you guilty, sentence you to 2 days with credit for 2 days time served. In 2020 MM 8657 AO, I'll adjudicate you guilty, sentence you to 2 days with credit for 2 days time served. All of those cases and counts will run concurrent. I'll order court costs in each case, and those will be due by 12/7/2021. That gives you a year. If you'd like to appeal the judgment and sentences of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. Good luck, sir.
And Your Honor, just a
Hold
suggestion that he
on.
not drive without a valid driver's
Okay,
license.
well, I mean, it's part of the law, so don't drive without a valid driver's license, okay?
Okay.
All right, tell me your name.
Darwin Osorio.
All right, Mr. Osorio, you're here in 2020 CT 4961AO. It looks like you failed to appear for a pretrial conference. The judge did set your bond at $1,000. And I have a form for the public defender, but you're not gonna qualify. Do you wanna try to resolve your case today?
Yes, ma'am.
Okay. You don't have any prior criminal history. Ms. Bush, do you have an offer?
Yes, Your Honor, it's a withhold of adjudication, 2 days Orange County Jail, 2 days credit time served, and do not attach tags that are not assigned to a vehicle in court costs.
Okay, do you want to do that, Mr. Osorio?
2-day jail?
You already have credit for 2 days.
Oh, so I get out today?
Yes.
Oh, sure, yes, sure.
Okay. Did you read the plea form?
No, ma'am.
Are you American citizen?
No.
Nope, but
And Your Honor, Mr. Thompson's speaking to him as a friend of the court?
yeah.
Yeah, as a friend of the court. I'm sorry, Mr. Thompson, I thought I appointed you. I think he walked over there on his own without me asking, but I don't recall asking him to talk to him, so.
No. Because I don't believe he qualified.
He didn't qualify. I didn't ask Mr. Thompson to, I think you just walked over there.
Yeah, I just walked over there. I just
Okay.
letting him know about immigration concerns.
Okay, thank you. All right, so, Mr. Osorio, you want to enter the plea?
Yes.
Okay, and you've read the plea form?
Yes.
Okay, do you understand everything on the plea form?
Yeah, kind of. Yes.
Kind of,
Yeah,
yes?
I mean, yes, please.
Okay, what don't you understand?
No, everything I understand, ma'am.
Okay. You understand all those constitutional rights that you're giving up by entering the plea?
Yes.
There won't be a trial, you won't have to make the state prove to the jury or a court beyond a reasonable doubt that you committed the offense, okay? All of
Okay.
those things you understand?
Yes, ma'am.
Okay. Are you on probation anywhere?
No, ma'am.
Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
All right, I do find that there's a factual basis based on the affidavit in the court file, the criminal traffic violation. I'm going to withhold adjudication, sentence you to 2 days with credit for 2 days time served. Do not attach tags to vehicles that they're unassigned to, okay?
Okay.
And court costs, I'll order you pay those by December 7th, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you, sir. Good luck.
Okay, so I got all right now.
Good morning. Tell me your name.
Derek Sutherland.
All right, Mr. Sutherland, you're here in 2020 MM 8662AO. It's a resisting an officer without violence. There's probable cause. I'll appoint the public defender. That bond will, I'm going to place you in pretrial release for everything, okay? And then you also have a 2020 CT 7549AO. It's driving under the influence. There is probable cause. I'll appoint the public defender. No drugs or alcohol without a valid prescription. And again, I'll place you in pretrial release, okay?
Yes, ma'am.
All right, good luck, sir.
Oh, that's it? Oh.
All right, do we have any arraignments coming? No? Is everybody medical?
Medical.
Everybody? Okay. All right, so Domingo Chalk Lopez.
medical.
Medical, 2020 CT 1493AW. Mr. Thompson, the PD was previously appointed. Do you want to enter a plea of not guilty?
Yes, Your Honor.
And he also has 2020 CT 1494AW as well. And so we'll enter pleas of not guilty. Thank you, Madam Clerk.
As Division 83, pretrial conference date will be January 20th at 9 a.m., courtroom 6C.
All right, now I've got Robert McCool,
Medical.
2020 CT 1002AA. The PD was previously appointed. And Mr. Thompson, do you want to enter a plea of not guilty?
Yes, Your Honor.
Division 84, pretrial conference date will be January 11th 10 a.m., courtroom 4B.
And Donald Gordon, 2020 MM 85559AO, and the public defender was previously appointed. And Mr. Thompson, do you want to enter a plea of not guilty?
Yes, Your Honor.
Okay.
Division 80, pretrial conference date will be January 14th, 9 a.m., courtroom 9C.
All right, Sheila Milton.
Medical.
And she is not in jail in this case. It was a notice to appear. I'm going to appoint the public defender to represent her. And Mr. Thompson, do you want to waive?
Yes, Your Honor.
Okay.
And for the record, Your Honor, the summons is in process of being served.
Oh, it was a notice to appear.
Yes, but
Oh.
we filed an information.
Oh, okay. Well, then we'll have to reset it because she was not served with the summons.
Yes, Your Honor, she has not been served.
Okay, thank you. They put notice to appear on here, so I wasn't aware there was a summons. Okay. So we will not take any action on Miss Milton's case. The summons has not been served. And we will reset her when the summons has been served. But not until. Okay, I do see a summons was issued. Okay. Thank you, Ms. Bush, because I did not know that. All right, and finally, Deanna Shook.
Medical.
Okay, let me see. Was this a note? Did you file an information on this one too?
Your Honor, as far as I could tell, this one did not need a summons.
Okay. And information was filed. So she was served with a notice to appear, and then an information was filed. What's the difference between the other one and this one then?
Your Honor, on the other, I saw that there was nothing that indicated that she was in jail on that particular case. In this, she is listed, this defendant is listed as being in jail on this case with this case number. And I believe that that's because she was arrested on December 3rd.
I just don't show that she was ever served with a summons.
And Your Honor, I can't speak to that, but because there was an arrest in this matter, I did not have to request a summons to be issued or served. In Ms. Hilton's case, she was in jail on unrelated matters and not on the matter that was on today's docket. So she had never been arrested on the case in any way. And in Ms. Shook's case, she was arrested on this case on December 3rd.
Yeah.
So as long as
I just don't know if she should have been, but
as long as an arrest was affected, because it does appear that there was, and I didn't see anything, I didn't really explore other than the fact that she was arrested. But I can look now and see.
so, there was a notice to appear back in July, then the state filed an information, and it was set for an arraignment. She was never served with there was never a summons issued for the information. Show court minutes from Judge McGinnis to reset the arraignment in 2 weeks and send notice to her new address. And then there was a failure to appear. Judge Bain issued the capias. I just don't know if.
And in that regard, Your Honor, because she was actually.
And her mail was returned.
So if there was not a summons,
I think there needs to be a summons.
then I will.
Yeah.
I'll make a request for a summons.
Because after the information was filed, there needs to be a summons. And it doesn't appear as if the notice that was sent, the reset notice, was returned as unserved. So I'm not going to take any action on the case today. And this, we'll just put in there that the state is to issue a summons and have defendant served. She was never served with any summons. So if we could just put that in the court minutes, the state to issue summons, never served with a summons. All right, do you need a moment, Ms. Bush?
Yes, Your Honor.
Okay. Fill that out for me before I sign it. I don't know what it is. Don't fill anything out. Thank you. Did we have an add-on today?
We had one.
Okay,
And it was an out-of-county status hearing.
Okay, I don't know what that is. Okay.
And I'm
Is Mr. Mazzarelli coming? Medical? Okay. So the public defender was previously appointed. This is a Monroe County status hearing. And Mr. Thompson, do you want to waive?
Yes, Your Honor.
All right. Per Judge Jones, the bond is to remain at none.
Your Honor, it'll be about 2 more minutes.
Sure. I know. I can't even wear mine. I just have to go blind.
state's ready, Your Honor.
Okay. All right. My first case, 2020 CF 8973, James Westmore.
And information was filed on December 4th. Filing ID is 117659036.
All right, that's denied. CF 12666AO, Alexej Ulahines.
I will leave that with the court.
I don't know how to pronounce that. That's my best pronunciation.
I couldn't even pronounce it in my head, so a notice of non-filing on December 4th.
All right, that's granted. 2020 CF 11781AO, Wilanov Guli.
A notice of non-filing on December 4th.
All right, he was arrested on 9/29/2020. Bond was filed on 10/17/2020. His release was revoked on 10/29/2020. And so the proper motion to file would be a motion to set bond.
And Your Honor, the state missed that. That's actually a last-minute thing that I was trying to look at. The state would ask the court to deny the motion as bond was previously been revoked pursuant to the rule and case law.
All right, that will be denied. CF 13219AO, Antron Savante Sanders.
And information was filed on December 4th. Filing ID is 117696323.
Denied. 2020 CF 13162AO, Stefoin Mika Lilly.
A notice of non-filing on December 4th.
That's granted. 2020 CF 9730, Lance Antonio Williams. This was also a case where his release was revoked.
His release was revoked on October 20th based on a new law arrest in 2020 CF 12559.
And no information's been filed?
Correct, no information has been filed. The state would ask the court to revoke pursuant to Parker and statute.
Right, that's denied. 2020 CF 13094AO, Emmanuel Marcano.
A notice of non-filing on December 4th.
Right, that's granted. Is that a the city of Orlando, the city prosecutor, did they have this case too? Because they're in the certificate of service along with the state attorney's office, so I may just cross them out unless they're a party.
I don't know because we don't have city cases.
They're in almost every single, I don't know why. Okay.
But in our records, they are not.
Okay. Mr. Thompson, you may want to find out who's doing these because they're putting both the city of Orlando and the state attorney's office. Well, this one does not have the state attorney's office. It has the city of Orlando only.
Okay, Your Honor.
So I'm gonna cross them out and put, and it's the same for some of these other ones too.
I'm sorry, what's the case number on that one, Your Honor?
This is 2020 CF 13094 AO, Emmanuel Marcano. And now that I'm looking back, the last case that I did, Lance Antonio Williams, also has the city prosecutor. So you guys are not copying the proper agencies. So I'm gonna cross them out and put in the right ones.
I'm sorry, what was the case number for the one before?
2020 CF 9730 AO, Lance Antonio Williams.
They're both done by the same attorney. I'll let her know today.
All right, I crossed it out and put the right one in.
Okay.
Okay. 2020 CF 13215, Omari Landry.
A notice of non-filing on December 4th.
All right, that's granted. 2020 CF 12233, Leharian McQuace Payne.
And information was filed on December 4th. Filing ID is 117698910.
You said December 4th, Ms.
Yes, Your Honor.
Okay, thank you. All right, and finally, 2020 CF 11993 AO, Joshua Lee Highfill.
A notice of non-filing on December 4th.
All right, that is granted. I think that's it. Anything else for the morning?
Nothing from the state, Your Honor.
Okay,
Nothing in defense, Your Honor.
you're on recess. declare back on the record at session 2 on December 7th, 2020. This is Judge Wish. Can I have the parties announce themselves for the record, please?
Good morning, Edith Bush for the Office of the State Attorney.
Chase Thompson on behalf of the Office of the Public Defender.
And I'm recalling 2020 CF 14506AO. That was Bruce Eric Lewis Jr. I previously found a lesser included offense of child abuse for count 1. Counts 2, 3, and 4. The state had previously requested additional 24 hours to provide probable cause. They are withdrawing that request, so we will not reset the case for tomorrow. And I did find, so what I'm going to do is find probable cause for the lesser included offenses of battery, domestic violence, which is, what is it, 784.03-10.
Yeah, I don't know the dash. Is it 10?
I think,
Okay.
yeah. So 2, 3, and 4 will be battery, domestic violence, the statute that I just indicated, and we will not reset. And I did already set bonds on those counts at $500 on each count.
Yes, Your Honor.
Okay, so we do not need to have that reset for tomorrow. Thank you, Ms. Bush.
Thank you.
Okay. Mr. Cunningham?
Cunningham.
Good morning, sir. Tell me your name. Mr. Cunningham?
Right. Triquan Cunningham, yes.
Okay. Mr. Cunningham, you're here in 2020 MM 8659AO. You're arrested for petty theft.
Yes, ma'am.
I do find that there is probable cause, and I don't have a form for the public defender. Did you plan on hiring your own attorney?
No, ma'am.
No. Well, you don't have a history. And so I don't think it's a good day to resolve the case. Do you want me to see if you qualify for the public defender, and then when you get downtown, maybe you'll qualify for pretrial diversion, which is a program the state attorney's office runs, and if you complete everything successfully, the charges will get dismissed. I don't know if you'll qualify, but they may refer you to that program.
Okay.
Because I don't know if you're too familiar with the criminal justice system. You don't have anything going on. You don't.
No, I don't know nothing about it. Cause like, since I've been a juvenile, like, this my first time being arrested,
Okay.
so
Okay.
I don't know.
Do you want me to see if you qualify for the public defender?
Yes.
Okay. Are you working right now?
No.
Do you get any income from any source?
No. No, ma'am.
Okay. All right. I'm going to appoint the public defender to represent you. You can't go back to the mall that this occurred at. I think it's the Florida, or excuse me, Mall of Millennia. You can't go to any Macy's, not to have any contact with any victim, witness, or co-defendant, and you are trespassed, so you must abide by the trespass warning. I am going to place you in pretrial release. Make sure you comply with those orders. See about the pretrial diversion, okay?
Okay.
All right, good luck. Good morning. Tell me your name.
Zachariah McKnight.
All right, Mr. McKnight, you're hearing 2020 MM 8658AO. You're arrested for petty theft. There is probable cause. I'll appoint the public defender. Ms. Bush, did you have an offer?
Ma'am?
Mr. Mr. McKnight, you're out on bond for carjacking.
And Your Honor, At this time, the state does not have an offer, Your Honor.
Okay, so Mr. McKnight, you're not to return back to the Mall of Millennia or any Macy's. You're to abide by the trespass warning that you were given. No contact with any victims, witnesses, or co-defendants. Your bond on the petty theft will be stayed at $250. I am revoking the bond in 2020 CF 3376AO. I am setting the bond at $25,000. You do have the public defender or an attorney on that case.
Can I have a moment, Your Honor? All right, thank you, Your Honor.
Good morning, tell me your name.
Good morning, my name is Chanel Pugh.
Ms. Pugh, you're here in 2020 MM 8653AO. You're arrested for battery and making false 911 calls. There is probable cause. I don't have a form for the public defender. Are you planning on hiring your own attorney?
I would like to speak to you for myself.
You're going to represent yourself?
Yes, ma'am.
Okay, well, you'll have to discuss that with the judge downtown. You're not to have any contact with any victim or witness, not to possess any weapons, firearms, or any ammunition. Your bond will stay set at $500. Count 2 will be $100.
Well, I can't speak to you right now at all. Like, no.
I'm not going to resolve your case today. The victim has a right to be heard. It's a battery, ma'am. Good morning, tell me your name.
Elizabeth Roddy.
Miss Roddy, you're here in 2020 MM 293AE. You're arrested for battery. There is probable cause. I'll appoint the public defender to represent you. You're not to have any contact with any victim or witness, no drugs or alcohol without a valid prescription, no weapons, firearms, or any ammunition. I'm placing you on pretrial release.
Thank you so much for that.
Good morning, tell me your name, please.
John Abelscape Jr.
Mr. Scaife, you're here in 2020 MM 8660AO. You're arrested for trespass on property after warning. There is probable cause. And Ms. Bush, did you have an offer?
Yes, Your Honor. It's an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served, no return to the Wawa on West Colonial Drive, abide by all trespass warnings, no contact with victim or witnesses, and court costs.
Mr. Scaife, did you want to accept that offer?
Yes, ma'am.
Okay. Did you read the plea form?
Yes.
Did you understand everything on the plea form?
Yes, I do.
Do you understand all the rights you're giving up by entering the plea?
Yes.
Are you on probation anywhere?
Oh, ma'am.
Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
All right, I do find that there's a factual basis to accept your plea based on the affidavit in the court file. I'll adjudicate you guilty, sentence you to 5 days with credit for 2 days time served. No return back to the Wawa at 1200 West Colonial Drive. No contact with victims or witnesses. Abide by the trespass warning. Pay your court costs by December 7th, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. Good luck. All right, good morning. Tell me your name.
Corey Son.
Mr. Sun, you're here in 2020 MM 1000 AW. You're arrested for trespassing in a structure of conveyance. There is probable cause. Ms. Bush, did you have an offer?
Yes, Your Honor. It's an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served. No return to the Calvary Baptist Church on South Dillard Street in Winter Garden. Abide by all trespass warnings. No contact with victim or witnesses, and court costs.
All right, Mr. Sun, did you want to accept that offer?
No.
No? Okay. So you're not to return back to the Calvary Baptist Church at 631 South Dillard Street. No contact with any victims or witnesses. Abide by the trespass warning. Do you live in Orlando? Or you live in Winter Garden?
Winter Garden,
Okay. Do you have a place to live?
yeah. Yes.
You do? Okay. Is it the 523 South Woodland Street?
Yes.
That's where you get your mail?
Yes, it is.
Okay. So if you move, you need to make sure you let the clerk's office know, because any notice is going to go to that address. Okay?
Okay.
Do you want me to see if you, I think you're going to qualify for the public defender. I'd like to appoint them to represent you so that you have somebody to talk to and you don't miss court. Can I do that?
I'll probably just represent myself.
Well, it's not always a good thing to do.
I understand.
Okay, well, if you miss court, that's not going to be an excuse that, you know, you didn't know.
No, yeah, I have to
Okay.
go to court. I understand.
All right, so make sure you don't miss any court dates.
So
When
you give me
get
a
out,
court-
you're going to get a court date. I'm going to release you on your own recognizance. You cannot go back to that location. If you go back there and get arrested again, your bond could be revoked, okay?
I
Or
understand.
I'm sorry, your release. All right? Thank you.
Yes, sir. Right here.
All right, tell me your name.
Troy Thomas.
Mr. Thomas, you're here in 2020 MM 8655AO. You've been arrested for trespass in a dwelling after warning. I find probable cause for trespass on property after warning. I think that was a Scrivener's error on the part of law enforcement.
Yes, Your
So
Honor.
it's 810.09-5, which is trespass on property after warning. Okay, so now that we've got that, Ms. Bush, did you have an offer?
Yeah.
Yes, Your Honor. It'd be an adjudication of guilt, 5 days Orange County Jail, 2 days credit time served. No return to the West Church Street Food Mart at 2503 West Church Street in Orlando. Abide by all trespass warnings, no contact with witnesses or victim, and court costs.
All right, Mr. Thomas, do you want the 5-day offer?
You're right.
You do?
Right.
Okay. You want to stay here a couple days?
Right.
Okay. All right. Did you read the plea form?
I didn't read all of it.
Okay, why don't you go ahead and read it,
All
okay? And let me know when you're done.
All right. All right.
Okay. Did you understand everything on the plea form?
Right.
You understand all the rights you're giving up by entering the plea?
Right.
Are you on probation anywhere?
No, no.
Okay. You understand if you're not a U.S. citizen, the plea will subject you to deportation. Is that a yes?
Yeah.
Okay. All right, I do find there's a factual basis to accept your plea based on the affidavit. I'll adjudicate you guilty, sentence you to 5 days with credit for 2 days time served. You can't go back to the West Church Street Food Mart at 2503 West Church Street. Abide by the trespass, no contact with victims or witnesses. I'll order you pay your court costs by December 7th, 2021. It gives you a year. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you, sir. Good luck.
Your Honors, Ms. Nikki Warren, mental health.
Okay, I'm gonna appoint the public defender for Miss Warren in both of her cases. Well, does she have the PD already in the other case? It's a failure to appear. That's 2020 MM 5052 AO. If not, I'll appoint them to represent her. She has a $2,000 bond in that matter. 2020 MM 595 AA. It's a petty theft. There's probable cause. I'll appoint the PD. Okay, she already has the PD in the other one. No return to Walmart. That she was. The failure to appear. She doesn't. She already has the PD, right? No, right. That's the new case. Okay. Yeah. No return to the Walmart. No contact with victims or witnesses. Abide by any trespass warning, and also no drugs or alcohol without a valid prescription. That bond will stay at 500.
Okay.
All right, tell me your name.
Jefferson Millard.
All right. Sir, you're here on an open container violation in 2020 MO 1298. There's probable cause. Ms. Bush, did you have an offer?
Yes, Your Honor. It's an adjudication of guilt. 4 days Orange County Jail, 2 days credit time served, and court costs.
All right, Mr. Miller, did you want to do that? I'll get you out tomorrow.
Today?
Tomorrow.
Tomorrow? Yeah.
You want to do that?
Yeah. Mm-hmm.
Did you want to get out today?
Yes.
Well, Your Honor, if that's the case, I'm just looking at the forecast.
Okay, I think Miss Bush is just thinking about the cold weather, and she's just thinking maybe you want a place to stay tonight.
And I can go to my girl house instead.
Okay, you're gonna go to your girl's house?
Okay. If that's the case, it would be adjudication of guilt, 2 days Orange County Jail, 2 days credit time served, and court costs.
Okay. Well, Mr. Millard, you just negotiated yourself a credit for time served offer. There you go.
Thank you, ma'am.
All right. Did you read the plea form?
Yes, ma'am.
Did you understand everything on the plea form?
Yes, ma'am.
You understand all the rights you're giving up by entering the plea?
Yes, ma'am.
Are you on probation anywhere?
No, ma'am.
Do you understand if you're not a U.S. citizen, the plea will subject you to deportation?
Yes, ma'am.
Okay. Do you find there's a factual basis to accept your plea based on the affidavit? I'll adjudicate you guilty, sentence you to 2 days with credit for 2 days time served. Pay your court costs by December 7th, 2021. If you'd like to appeal the judgment and sentence of the court, you must do so in writing within 30 days. If you cannot afford an attorney, one will be appointed for you. Good luck.
Thank you, ma'am. So I'm going home today?
You'll get out today.
Thank you.
Okay. All right, tell me your name.
Robert Adams.
All right, Mr. Adams, you're here in 2020 CF 14479AO. You're arrested for possession of cocaine. I don't find there's probable cause. The drugs were not tested. They were submitted to FDLE for further testing.
Yes, Your Honor, and I've already put a request in to Orange County. I'm going to ask for 24 hours, Your Honor.
Okay, so the state's asking for 24 hours, so the bond will stay at the $1,000. It will be reset tomorrow if you don't bond out. And so no drugs or alcohol without a valid prescription. 2020 CF 6740AO, it's a failure to appear. And that was for a status hearing, December 3rd, 2020. The judge did set your bond at none. Does he have the public defender? Okay, you already have the public defender in that case. They're going to have to file a motion in that case to get you a bond, okay? And then 2020 CT 7548. There's driving while license suspended. There is probable cause, and I'll appoint the public defender in that case. That bond will stay at $500. You're not to drive without a valid driver's license. So I don't think you're going to be bonding out because of the no bond. So it will be reset tomorrow.
And Your Honor, I apologize. I realized that I actually came to a resolution when I talked to Orange County. And I'm going to withdraw that 24-hour request as well.
All right. So pursuant to the state's request, so I'm finding no probable cause for the cocaine. There's no conditions of release on that, Madam Clerk, just so we're aware. It will be ROR'd. That doesn't mean that the state can't later charge you with that, okay? Mr. Adams, they can send it off to FDLE and then get a warrant and arrest you or file the information, okay?
Okay.
Just so you're aware.
All right.
All right? Okay. So get with the public defender. They're going to have to file a motion to set bond for you on the other case. Okay? All right. Good luck. All right, good afternoon. Tell me your name.
Mark Kane.
All right, Mr. Kane, you're here in 2020 CF 1306AO. You failed to appear for trial management conference on October 8th, 2020. The judge did revoke the release but gave you a $500 bond. Does he have the public defender? Nope. Okay. Do you want me to see if you qualify for the public defender?
Yes.
Okay. Are you working?
No.
You are?
No.
No. Okay. Do you get any income from any other source?
No, ma'am.
Okay. I'm going to appoint them to represent you. So if you're unable to make the bond, they'll be able to file a motion for you. Okay? Okay.
Your Honor, Vincent Giacola, bonded.
Okay. We'll take no action. All right, tell me your name.
Megan S. Holler.
All right, Ms. Holler, you're here in 2020 CF 14494AO. You're arrested for petty theft.
Yes, ma'am.
And possession of alprazolam.
Yes,
There is
ma'am.
probable cause. Do you want me to see if you, well, you have the public defender in your other case, but I don't, did you fill out a form? Her name is Holler?
I did.
Okay. I think, yes, that's Ms. Holler. Okay. I'm going to appoint the public defender to represent you in your case. So no contact with any victims or witnesses, no drugs or alcohol without a valid prescription, and no return back to the Walmart at 3101 West Princeton Street.
Yes, ma'am. Does this mean I can bond out now?
Hold on.
Oh, sorry. I'm so sorry.
We're almost there.
Okay.
I'm going to stay the bond at the $250 and the $1,000. I'm not taking any action on your other case. You have a court, well, you had a court date. I don't know when your next.
In January, I do
January
believe.
26, 2021.
Yes, ma'am.
So don't miss your court date. Don't get arrested for anything because
No,
your bond is
ma'am.
going to be revoked, okay?
Okay.
All right, good luck, ma'am.
Okay. God, thank you so much.
All right, good afternoon. Tell me your name.
David Miller.
Mr. Miller, you're here in 2020 CF 14498AO. You were arrested for grand theft of a motor vehicle. There is probable cause. I'll appoint the public defender to represent you. No contact with any victims in the case. You're not to drive without a valid driver's license. Your bond will be set at $2,500. I'm not taking any action on your out on release case.
Thank you.
You have a court date coming up in January. You do have the public defender. Don't miss court. Don't get rearrested for anything
Yes,
because
ma'am.
chances are it's not going to be a good day if you come back.
I ask for a bond reduction?
I'm sorry?
Can I ask for a bond reduction?
Sir, you're pushing it. Tell me your name, please.
Gonzalez.
Okay. All right, sir, you're here in 2020 CF 14495AO. You were arrested for possession of heroin. There is probable cause. Do we have a form for Mr. Nadal Gonzalez? No? Did you fill out a public defender form, sir?
Yes, yes, ma'am.
You did? Okay. We don't have one for you. No. All right. Are you working? No? Okay. I see you have the public defender in the other case, so I'm going to appoint them to represent you. No drugs or alcohol without a valid prescription. You cannot return back to 2001 Americana Boulevard, Roses Plaza. Okay. Don't go back there. And your bond will stay at $1,000. You're out on bond in 2020 CF 10318AO. I'm revoking the ROR, actually it's ROR. I'm revoking the ROR. I'm setting your bonds at $1,000 on count 1. Count 2 will be $150 and count 3 will be $150. All right, good afternoon. Tell me your name, please.
Robert Ramos.
All right, you're here in 2020 CF 14496AO. You're arrested for possession of heroin. There is probable cause. I'll appoint the public defender. You're not to return back to Roses Plaza at 2001 Americana Boulevard. No drugs or alcohol without a valid prescription. Your bond will stay at $1,000. Thank you, sir. All right, good afternoon. Tell me your name.
Romello Smith.
All right, Mr. Smith, you are here in 2020 CF 14492AO. You're arrested for possession of cannabis less than 20 grams and 3 counts of possession of a controlled substance without a prescription and possession of cocaine. And there is probable cause for those offenses. Do we have a form for Mr. Smith? Did you fill out a form, Mr. Smith?
No, ma'am.
Okay, did you want me, are you gonna hire your own attorney?
Yes, ma'am.
Okay. No drugs or alcohol without a valid prescription, no contact with any witnesses in the case, and you're not to return back to where the offense is alleged to have occurred. I'm gonna place you in pretrial release. You qualify for that. Make sure you don't violate those conditions of release, okay?
Thank you.
All right, good afternoon. Tell me your name.
My name is Letitia Talley.
All right, Ms. Talley, you're here in 2020 CF 13484. You were arrested pursuant to a warrant. Probable cause was found for aggravated assault and battery. I will appoint the public defender to represent you in your case. You're not to have any contact with any victim or witness, no weapons, firearms, or any ammunition. You're not to return back to the Walmart at 2500 South Kirkman Road. Your bonds will stay at $1,500 and count 2 is $500. I am revoking your bond in 2020 CF 9847AO and setting the bond at none. Does she have the public defender? Okay, you have the public defender. They're gonna have to file a motion to set bond for you in that case. Thank you, ma'am.
Okay.
All right. Good afternoon. Tell me your name, please.
My name is Joe.
Keep it up, keep it up.
Can I get up?
Yeah, you can stand up.
Tell me your last name.
My last name is Vertus, E-R-T-U-S.
Okay, Mr. Vertus, you're here in 2020 CF 14499AO. You're arrested for battery on an emergency medical care provider. There is probable cause, and I'll appoint the public defender to represent you. You're not to have any contact with any victim or witness. No weapons, firearms, or any ammunition. You're not to return back.
I don't carry nothing. I have nothing to do with it.
Okay, you're not to return back to the Health Central Orlando Health at 10,000 West Colonial Drive unless you're being treated medically. You cannot go back there, okay?
10,000 West Colonial Drive.
Yeah, that Orlando Health Central, okay?
So, can I say something about what happened last night?
I don't want you to talk about what happened. It's not a good idea, okay?
Okay.
All right.
Oh, okay.
And so I'm gonna set the bond at $500.
Mm-hmm.
All right, thank you, sir.
Okay. I got charged for nothing. Yeah. You could put your hands on me.
All right, good afternoon. Tell me your name.
Austin Meyer.
All right, do we not happen to Travis Zipperer?
He bonded, Your Honor.
Okay, we'll take no action on Mr. Zipperer. You're Mr. Meyer?
Yes, ma'am.
Okay, Mr. Meyer, you're here in 2014 CF 16334BO. This is a violation of probation warrant. The judge did set your bond at none. I'm gonna appoint the public defender. You'll see Judge Whitehead in a couple days for your arraignment, okay?
Yes, ma'am.
Good luck. All right, good afternoon. Tell me your name.
Donna Patterson.
All right, Ms. Patterson, you're here in two cases. First, I've got 2020 CF 14480AO. It's possession of cocaine and possession of cannabis less than 20 grams. I'm going to appoint the public defender. This is the co-defendant in the other case. I didn't find probable cause for the cocaine, Ms. Bush, so. I don't find probable cause for the cocaine. I do find probable cause for the cannabis less than 20 grams. So are you not requesting more time?
I'm not requesting more time.
So I'm gonna ROR on count 1. Count 2, I'm gonna ROR on count 2. However, you're on probation. So no drugs or alcohol in that case. You're on probation in 2015 CF 15990, and so there is PC for the VOP on view. I'm gonna appoint the public defender in that case as well. That bond will stay at none at this time. So your probation officer will have some time to file an affidavit if they're going to, okay? If not, then you'll be released at some point, but you'll see Judge Whitehead in a couple days, okay?
Okay.
Good afternoon. Tell me your name.
Christopher Clark?
Mr. Clark? Okay.
Yes.
You're here on, I'm in a Marion County warrant. I'm gonna appoint the public defender here. You have a $2,000 bond. So if you can bond out, you can bond out. Okay? All right.
Okay.
All right, tell me your name.
Deshaun Reyes?
Okay, Mr. Reyes, you're here on an Osceola County warrant. There was a bond correction as to count 1. I believe you do have a $500 bond on count 1. Count 2 is set at none. It's domestic violence battery. So I'm going to appoint the public defender here. We'll reach out to the judge in Osceola County and see if they're going to give you a bond and conditions of release on the domestic violence battery, but I can't do anything today, okay? So I've appointed the public defender. You can reach out to them, but we'll bring you back to court when we hear back from the judge in Osceola County, okay? Or they'll pick you up, okay? But you got to bond out on the first count.
Okay, so if I bond out on the first count, then what does that mean?
They'll come and get you, or you'll hear back from us first. It's just, I don't know what order it will happen, but we'll see if we can give you a bond and conditions of release on the DV case, okay?
Okay, do you know when, like as soon as that will be being, like processed?
I'm not the judge that contacts the judge in the other county, so I can't tell you that. But we'll bring you back, but they might pick you up before that, but you'll still have to bond out,
Okay.
okay? I think he'll still have to bond out on count 1, or maybe not, because it's Osceola. You might not have to. I don't want to give you any legal advice. Mr. Thompson, do you know? I think maybe they'll pick him up because it's still the Osceola County and he's no bond on 1 count.
Yeah, Osceola transporting.
They are transporting.
Yeah, they'll pick him up.
So I don't think you have to bond out on count 1. I think I'm just used to saying that because in Orange County case you'd have to. Okay. Does that make sense? Okay.
Yes.
So I don't think you have to bond out on the first count in order for them to pick you up because it's 1 case.
Okay.
Okay, you don't have a case here and then a case there. So you should be okay if you don't bond out, but I can't tell you when they'll come and pick you up, okay? Maybe that's a better way to explain it. All right? All right, good luck, Mr. Reyes.
Thank you.
I'm so used to having 1 case and then another case, so that was bad advice. Okay, anything else? Nope.
No, Your Honor.
Okay, we are done for the day.